Recording start.
Yeah. Good morning, friends. I welcome you all. Uh, Being the president of Rera Practitioner Welfare Association, on the eve of this 73rd Republic Day of India, on this technical session on the discussion on the recent Supreme Court judgment in the matter of Newtech promoter. Today we are fortunate to have with us the ex-judicial member Sri Suman Koleji of Appellate Tribunal Maharera with us, and I would say rather ke being a chief guest, we could not have find a better person than Sri Suman Koleji, because the journey of the dispute as to the jurisdiction of authority and the adjudicating officer started on 31st August 2020, when the divisional bench of appellate tribunal pronounced the judgment in the matter of Pankaj Agrawal. So here the jurisdiction issue was discussed, and we all professional who used to attend Maharera or the tribunal, or even those professionals who were not to attend, uh, were discussing this judgment at large, because everyone was taken by surprise. How can this happen? Adjudicating officer does not have power to entertain a complaint wherein the refund of principal and interest is concerned. Means his role is confined only to section 71 and section 72. So this was all the things which we have discussed. Friends, on this particular day, Republic Day, we have adopted our constitution, and as we know, we are the largest democracy in the world, and we have three layers of the democracy, that is legislation, executive, and judiciary. So the role of legislation is to enact the law, to frame the law, whereas the role of executive, like Maharera, is to implement the law. And then comes judiciary. Whenever there are litigation, then judiciary will interpret the law, taking into the cognizance the public interest and everything. So the role of judiciary is very much important, and we acknowledge the role of Sri Suman Koleji being in appellate tribunal for more than 2 years. There are n number of judgments which were pronounced, and one of them was this Pankaj Agrawal, wherein we all were taken by surprise. And then there were fight then at even Maharera, and even the learned adjudicating officer also. Then thereafter thereafter one judgment came Mumbai High Court, that is Marvel Sigma. Now here the contest was under section 40 subsection 1, that is recovery of interest. So there the question was whether refund can be part of that recovery warrant or not. That was the fundamental question. So there the Mumbai High Court observed and concluded that this word compensation includes everything. So again the controversy started whether the Pankaj Agrawal can now be read in conjunction with Marvel Sigma, and we can conclude that still adjudicating officer has role to play wherever there is a refund of interest and principal. But again, that was in a different context, that is for recovery of warrant. In that judgment, the jurisdiction issue was never challenged. So thereafter we had issues before Punjab and Haryana High Court in Janta Land. So the similar view was taken there also. Adjudicating officer only has the power to adjust the compensation under section 71. And now we have Newtech promoter Supreme Court judgment, wherein nearly 5 broad issues are discussed. And today our speaker, Advocate Satish Dedhia and Advocate Nilesh Gala, will make a detailed presentation on these 5 issues. There is one more issue which Newtech Supreme Court has considered, that is section 43(5), whether it is constitutional or not. So the only question remains is whether quantum is still in the hand of tribunal or not, because in that judgment, am I audible? Okay, Aditya?
Yes, sir, you are audible.
Aditya, am I audible?
Yes, you are audible.
Yeah, yeah. So if I would like Koleji to throw some light on this also, because Allahabad High Court has very well established that quantum is now 100% wherever there is a refund of principal and interest. But when I come to Newtech, the last concluding para allows the appellant to file an appeal within 30 days of the order of the Newtech, subject to compliance of 43(5), as may be decided by tribunal on merit. So now these wordings, whether still we can say that there are some discretion available to tribunal depending upon the merit of the each case. Now in the case of in the case of Maradia Chemicals Supreme Court, there also the similar issue was discussed and there the quantum was reduced. It was a case of a recovery by a banker. So there the borrower argued that, look, my secured assets are with the banker. So I should not be called upon to pay the entire amount before entertaining the appeal. So there the Supreme Court has considered that whether still we have any scope before appellate tribunal as to the quantum. Yes, constitutionality is now very clear as to the quantum, whether we have any scope or not. I would certainly like Koleji to deliberate on that. And one smaller point is the issue, there is one proviso to section 71, which state that if there is a matter pending before consumer forum, it can be brought before the adjudicating officer. So there it is not said that it can be brought under section 31, but under section 71. So again, this point has not been addressed somewhere. So whether still that whenever the withdrawal is there from consumer forum, whether adjudicating officer has still some role to play or not. So with this opening remark, now I request our chief guest, Sri Sumant Koleji, to address the gathering.
Good to all. I really thank you all for inviting me in this webinar. Actually, I may confess that after vacating the office of Rera Appellate Tribunal on 4th August, thereafter I had in fact no occasion to come with, to deal with subject of Rera. But once Mr. Nilesh ji compelled me that he pursued the matter with me. In fact, I was telling him that wait for some time, let me take some time. I don't have any day-to-day study or day-to-day contact with this subject for last 5 months. So it might be difficult for me. So he said that you see, you have given some judgments in appellate tribunal, and what we see that some of the judgments are almost the view taken by me is confirmed this way or that way. So in what way you had a first impression of deciding the matter in a particular way, the way which was finally confirmed up to the Honorable Highest Court of the country. So in that way, then I said that, okay, let me go through some provisions and then I will prepare myself. I tried my best to prepare myself at least to have some sharing of my knowledge, experience and study with you on this subject. Because what happened once upon a time, even if you dealt with this matter, even after a gap of long time, once you sit with the subject and go through hurriedly, even for 1 hour or 2 hours, you can very well get the idea what is there. So in that way, I have done it. I hope that it may be acceptable to you, but I leave it to you because after all, we are all crime of the legal profession. We all are brilliant officers from this sector. And we always think this way or that way. And interpretation of a particular provision that comes in our mind in the morning is likely to be changed till the evening, because that process is going on in the mind, whether the first view that was in my mind in the morning is really correct or not. So one should go researching, thinking, because that is very essential. Now let me turn to the subject itself. First, let us understand that whenever act is there, rules are always framed. And simultaneously, regulations are also prepared. Then for what purpose the rules are there? We must know, we must understand. Now it is specifically mentioned that in order to carry out the provisions of this act. Now you should understand the meaning of to carry out the provisions of this act. Now let us turn to the other section, section 85. What it says, that the authority is empowered to frame the regulations. For what purpose? It is simply mentioned that to carry out the purposes of the act. So definitely purposes of the act are different, and implementation, carry out the provisions of the act is different. That's why our rules are framed in such a way that even if a tribunal is there, appeal is to be filed, complaint is to be filed, in what way it should be filed, in what way it should be heard, in what way it should be adjudicated, everything. Rules are there to give us the way by which you can carry out the provisions of the act, whereas regulations are there to carry out the purposes of the act. So whenever the question of any breach of provision is concerned, many times we come across that not only the breach of the provision of the act, but breach of the provision of rule or breach of the provision of regulation also. Friends, one must not forget that rule and regulation should not be in any way in contradiction with the act. Actually, rule and regulations should be interpreted not to defeat the purpose, not to ignore the provision, and they should not be in any way contrary to the intention of the legislation in framing the act, in enacting the act. So all these things are to be seen harmoniously while coming to a particular conclusion for understanding any concept. Now let us turn to the landmark judgment of the Honorable Supreme Court. Recently, we have that with us. There are so many material points, important points, which we can say that finally decided by the Honorable Supreme Court. Rera Act is hardly 4 years old. We were waiting for some judgments from the Honorable higher courts so as to get the correct interpretation, so as to understand the correct meaning, and so as to implement of the act in correct way at our lower level, that is at the level of Rera or at the level of appellate tribunal. And in that way, if we see the first issue, because we have not much time with us, and I am also restricting myself, as I told Mr. Gala that I may take at least 30 minutes, you should keep alarm with you, because once I go saying something, then my family members very well know that he should be stopped. Otherwise, he will go on talking for hours together. So that should not happen in this seminar. That is what I feel. Because Rera is such a subject that once I started speaking, then I may take much hours, but I will restrict myself. Huh? So first issue that was decided, that is the retrospective and prospective application of Rera. One more word we learn, particularly after enactment of Rera, that is retroactive application of a particular provision or particular act. Now, what is retroactive? What is retrospective? We generally say not retrospective, not prospective, only prospective. No, not only prospective, both retrospective and prospective. But what is this retroactive? So this concept can be very well understandable if we go minutely, correctly through our judgment of Honorable Bombay High Court in Nilkamal Realtor case itself, because there the constitutional validity of Section 18 was challenged. It relates to the refund, interest, and compensation. In that case, when application of the Act to the transaction which had already taken place prior to the enactment of the Act, or which are still incomplete. In short way, we can say that if the project is incomplete, it is bound to be registered with Rera, and then it is applied. Rera is applied to it. And so in that sense, operation of this Section 18 under Rera is retroactive. Even if you enter into agreement in 2012, 2014, 2015, where there was no Rera at all, still Rera will come into picture once 1/5 May, 1/5 2017, the date on which the Rera is enacted, we once know it. So one matter was before me, that was Bombay Dang case. And in that case, the issue before me was that, and it was very vehemently argued that Nilkamal judgment was in respect of a retroactive application of Section 18 only. This matter is under Section 12. No doubt, both provisions are quite different. Even their application or breach of the both provisions may arise at some different time during the transaction. Section 12 initially comes into picture, whereas Section 18 might be coming into picture later on. Whatever it may be, we will not go into that detail. But while hearing that Bombay Dang matter, it was my approach, judicial approach, that what was the reason for treating Section 18 as a retroactive? Why the said reasons cannot be made applicable to Section 12 when we openly, fairly always say that refund compensation, refund interest and compensation, what we say 12, 14, 18, or like that 19. So these are similar provisions. Word compensatory relief, this is used. Section 8 is compensatory relief. Similarly, Section 12 is also compensatory relief. So in that way, I thought that both provisions are under one and the same act. Both are governing the same transaction between same parties. Intention behind both the provisions in framing those in this act is also the same and identical. Then why should not the ratio laid down by Honorable Bombay High Court can be safely made applicable to Section 12 also? So I dare to observe that Section 12 is also having retroactive application. So what happened? That matter was challenged as usual in the Honorable Bombay High Court, but fortunately, the view taken by me was further confirmed. And I think Justice Bhagan sir was there, and he also observed that retroactive application in respect of Section 12 is acceptable. Then whether Section 18 and 12 is the entire Rera Act? Not at all. And so the latest landmark judgment, the Honorable Apex Court has clearly held that Rera is retroactive in its application. Operation of Rera is retroactive. In order to understand the concept more clearly, we must have patience, concentration, grasping, full understanding of the original provision, all these things, and then we can very well get the crux. We can very well understand the ratio laid down by Honorable Supreme Court. Friends, now let us turn to another provision, another issue. But prior to that, I will just point out one thing. When I had written Bombay Dang judgment, in that judgment, para 26 is there. It is speaking about section 12 and its application as retroactive nature. In there, I have given one observation that was made by Honorable Bombay High Court in Neel Kamal Realtor case, but it is in respect of the matter pending before the Honorable Supreme Court prior to coming into Rera Act into force. The issue was the same. What about the breach of assurances, commitments, consents which were given by the builder at the time of booking or at the time of what we can say prior to agreement for sale? If those are not at all followed, leave aside the stage of execution of agreement, don't come to that aspect. What about that? Because in whatever is committed to me previously at the time of booking, I am inclined to take that flat. Then I decide that I should take it flat. Then no doubt it is my duty to see that whether all these things are once again appeared in the agreement or not, because that is the most important document that will be binding. It may override the first one. But what about that occasion? And then it was clearly a statement was made before Honorable Supreme Court that this issue is before us and we are in a process of framing act to that effect. We have separate provision in that. So it is not that section 12 is for the first time coming for determination in this way or that way. It was already there prior to the enactment of the Rera. So in that way, I said that then definitely 18 and 12 are on similar footing as far as retroactiveness is concerned. And let us go to now another important issue, that is jurisdiction of authority and adjutant officer. It's a quite debatable issue. It was a quite debatable issue. And always you decide the matter this way or that way. Always you will get some opposition to one view or the other view, because that is bound to be there. Even if you say it is an adjutant officer, somebody says no, it is authority. Even if you say authority, somebody says no, because it is AO. Because one who is agreed by the order is going to challenge it, whatever may be the ground, maybe the jurisdiction or maybe any other ground given under the act. So this is the best ground which can be raised and which can be taken. And since this being the new act, interpretation being the most important aspect, but I may share my view with you. We need the ratios and principles of the Honorable High Court and Supreme Court when you yourself are in confusion. What is the exact meaning of a provision? But if you are in a command, if you are so mentally sharp that your approach is definitely coming to the perfect meaning of the provision, then there is no need of any further support that this is confirmed, this is precedent, this is case law. And provision itself is clear. We don't want anything. We are damn sure. I'm confident. Yes, this is the only meaning. No interpretation of the provision is necessary to find out the exact meaning. So this is the way in which we can see the authority and what we can say that adjudicating officer. No doubt adjudicating officer is a retired district judge. But we cannot ignore that they are not full-time. Authority is full-time member. Second thing, authority appoints them, whereas authority is appointed by the government. Act says that authority will appoint district judge retired for the purpose of deciding the matters of compensation. Now, much is said about the word compensation, interest, and like that, or refund, or like that. Right from the beginning, after carefully reading all these provisions, even 71, 72, I was also quite sure that adjudicating officer is appointed only for determination of compensation. Because right from the beginning, our rules of Maharashtra state says that there are two forms, Form A, Form B. Form B is for compensation. Form A is for refund, interest, bas, stop here. But what we do, party wanted number of reliefs in one and the same matter. अरे आपने को ये भी क्लेम अपन कर सकते कॉम्पेंसेशन, चलो रिफंड मांगेंगे, इंटरेस्ट मांगेंगे और उसके साथ कॉम्पेंसेशन भी यही मांगेंगे. We include that clause in Form A only. So multiple reliefs are sought in one proceeding. In fact, rules provide a separate provision for claiming one of the relief out of that before different forum. But that third relief is of such a nature that we are so tired, exhausted in getting relief of refund and interest that we say that अरे बाबा ये नहीं मिल रहा तो वो क्या compensation मिलने वाला है, बस हो गया, अभी ये मिल गया तो भी चलेगा. This is the real fact. How many matters are there in which complainants succeed, or the attempt was there to decide refund and interest by only authority and thereafter compensation by adjutant officer? Tell me any. 4 years have gone after the enactment of Rera, application of Rera. Tribunal is working for 3 years. Rera is working for 4 years. I have not come across with any matter, any complainant, any builder who says that we got these reliefs differently, separately, before 2 separate forums. Why so? Because the issue was debatable. And that's why we were waiting for some final decision on this issue. What is the correct view? But how I do not know, but I had carefully gone through all these provisions and I was also quite confident that only compensation. Then it was not acceptable to my mind that a matter consisting of 3 reliefs decided by one forum is to be sent to the another forum for deciding third relief. This is not like that in civil code. Whether a particular party is a tenant or not is the issue involved, and it is to be decided under Tenancy Act and it should be given to the Revenue Authority for decision. It is not like that. Then what to do? 2 reliefs to 1 forum, and the nicety is that of findings given on first 2 reliefs will be deciding the consequences of third relief, in the sense that whether you can claim or not. If the authority is deciding refund is to be given, interest is to be given, then only compensation is referred to the AO. Then AO will say that, oh, claim is already decided. You are entitled for compensation. Now just I want to decide quantum. And different criteria for deciding the quantum are given there. But friends, we cannot forget that there are not always multiple reliefs as far as compensation is concerned. Compensation is such a relief, which is, after all, sometimes it is a consequential and ancillary relief, and sometimes it is a main relief. Where is the main relief as far as compensation is concerned? We have two provisions separate. Yeah, I may point it out that I think section 14 and section 12. One minute. There are 2 separate provisions. If the land on which the project is launched is later on, found to be defective, he can claim the compensation. That is only and only compensation relief. That matter did not come to authority. That should directly go to the AO, and our form B is there for that purpose. Similarly, structural defect found within 5 years to be informed immediately to builder, get it repaired within 30 days at the cost of builder, but is not ready, you spent it, recover it, get the compensation. Compensation will depend upon the nature of the defect and the expenses reasonably required for curing of that defect. And so that aspect can be very well dealt with by retired district judge who is having some judicial aspect, judicial approach. That is what I feel. So in that way, definitely I again come to one more point. Here only I will say that, you see, two reliefs which can be independently claimed as a compensation under 12 and 14. No, I think under 18.2, defective title of the land, and probably 14, that is structural defect. Both the reliefs I have not come across naturally, because take an example, project is started in 2012. It is completed in 2014. CC is received, completion certificate. Everything is finished before the enforcement of the Rera. Nothing remained. We casually say, if a project is registered, then only allot is there, promoter is there. Rights and duties are governed by the Rera Act. If it is not registered at all, then how? It is already over. CC is already issued. Everything is finished. What about these two provisions? When cause of action will be there? A flat purchaser taking possession in the year 2014 can agitate in respect of structural defect within 5 years, that is up to 2019 or 20, whatever it may be. So in 2019, can we say that, Mr. Allotee, you cannot, your project is not registered here. Neither you are allotee nor that builder is what we can say, that promoter. It is not permissible. Then another thing, defective title may be transferred after 10 years. So it is very wisely mentioned that there is no application of Limitation Act to this provision. Even after 10 years, it is found that the title of the land was defective, because defectiveness of the title cannot be ascertained within 6 months and 1 year or like that. If litigation starts between the original owners, subsequent owners, then builder who developed the land on that, who developed the project on that land, then those are to be decided by civil court. And it may consume time. So whatever it may be, the moment, even if after you satisfactorily staying there for 15 years, one fine morning you come to know, oh, the building on which your land is standing is having defective title. Come on, claim the compensation against the builder. Two different separate reliefs can be claimed, even no registration of project under Rera is there. And that's why the Honorable Supreme Court says that operation of Rera is retroactive. As far as authority and adjuting officer is concerned, we have already taken view in Pankaj Agrawal case. And once Nilesh told me about this webinar, then once again I have gone through that judgment, and I myself was satisfied that whatever I have written is quite appears to be correct. So that view, I need not repeat it. I will not read my judgment once again. Again and again, we should not repeat the same thing. But we can just say that two different authorities are there. Their jurisdictions are also different. And now there is no controversy at all what type of matter is decided by what type of authority as far as jurisdiction is concerned. And so that point is finally settled by the Honorable Supreme Court. And for that purpose, I will request you, as far as my views are concerned, once again, I may say that if you find some time, you may go through my draft of judgment, my brother's draft of judgment, Mr. Sandhu, in Pankaj Agarwal case. But I remember one thing. When the matter was closed for decision, then we were told that this issue is already pending before the Honorable Apex Court and like that. We did not touch, we should wait till the decision. But I also came from judiciary. It was also argued counterly that there is no stay, there is no any restraint to us from deciding the matter. Then should we stop? I know that one party is always insisting. They are creating pressure. Oh, Supreme Court के आगे है, मत हाथ लगाओ. अरे ठीक है, पर कहाँ हमको बोला है कि रुक जाओ? Are you going to stop all the matters in the country under this provision pending before various authorities? Daring should be there, and perfect judicial approach should be there. We should study more. We should exhaust more. I tell you, parties are always happy if their decision is supported by justifiable reasons. You make the party understand as to why this is against you. Once he is satisfied, that is the way in which he won the matter. Because after it is going to be allowed or going to be rejected. But your reasons should be so sound, so perfect, that it should have impression on the party that sir ne likha hai, wo sab barabar lag raha hai. We say that this is the achievement. And this is the way of administration of justice. That is what we require. अरे वो क्या सर ने तो पूरा provision ही सब बदल डाला. If it is a social legislation, if it is a social act, if it is a beneficial act, without disturbing the intention or object of the act, if there is discretion with you, no doubt social justice is somewhat different. But let the social justice enter into this matter to some extent. And that's why we say that relief can be molded. But how to mold, in what way mold, and in what way it should be acceptable. So I myself do not know, but I am quite sure that whatever was acceptable to my conscience, bona fidely, honestly, I try to find out the true meaning whenever the matter was before me. And probably we courage to declare the judgment, even if we were afraid of waiting for the order from the Honorable Supreme Court. But fortunately, the same thing has happened. But we see that to what extent we went. Not only that, we pronounced the judgment, we started implementing it. On the basis of that matter, you also accepted that judgment in the sense that you both parties suggested that, sir, send it back. Remand it. So in that way, it was accepted also. So we started implementing also. I thought that suppose this view is not held correct, what will be the effect? How much harassment of the parties in getting a relief under the special act? But you should have your own confidence, courage, and proper decision at proper time. Otherwise, if you keep silent on this point, then it is of no use. Okay, friends, then we will shift to some another point, that is the jurisdiction of single member of authority. That is also decided by the Honorable Supreme Court. And finally, it is held that even a single member can adjudicate. It's a quasi-judicial matter. Power of delegation are given under section, I think, 82 or like that. No, 82, no. I think 81, I think 81. Section 81, delegation of power. You see, due to gap of 5 months, I may commit such mistake. I may refer a wrong number of the act, but provision is definitely there. Delegation of power is there. Now the question was whether the delegation of judicial power also is covered under this or not. Honorable Supreme Court has said yes, that is quasi-judicial matter, and this can be why not? This can be delegated, and so it can be done by the single member also. Friends, I would like to point out that this aspect was also decided by me in this way only. Rajesh Chaudhary versus CCI judgment is there. I have decided it on 10th March 2021. In that judgment, I said that single member is having jurisdiction. An authority can delegate the power. I have referred section 82 also. At the same time, I have given some more different reasons. Whatever it may be, reasons may be different depending upon the way in which you are thinking, but your destination should be correct. If you are missing the destination, nothing doing. If your destination is correct, that is what we want. You reach there only, spot A. Either through C, through D, we are less bother. Sometimes D is more shortcut and perfect way. And D may be some cumbersome and long way. But after all, both are reaching there. In that way, if we think, the conclusion is correct. Single member can have a jurisdiction. On this point, I will take you to my two reasons which are of quite different nature. I have thoroughly studied Rera. I find out two occasions where this issue can be studied. What are those occasions? When Rera Act has come into force, the Act is made applicable immediately. Within 6 months, authority is to be established. Thereafter, within 3 months, authority has to frame regulations. Regulatory authority should be established by the appropriate government within 6 months. In our state, it was done earlier, as early as possible. So we had regulatory authority immediately after Rera. They started deciding the matter. What about the appeals? People started approaching Honorable High Court. Honorable High Court said that under Rera there is a provision of appellate tribunal. Why you are approaching here and increasing our burden? Then the government immediately established appellate tribunal. Then what about the period between decisions given by authority till the establishment of regular Rera tribunal? For the time being, the charge was given to another designatory authority, that is Maharashtra Revenue Tribunal. So they were in charge tribunal with us, and accordingly they decided the matter. Now, whenever such a designated authority is working, then we know that matters were also wait, please 2 minutes. I referred that designated regulatory tribunal can be appointed by the government till the regular tribunal is established. But under that section, one more clause is there. Or any officer, preferably secretary of the housing department. So whenever MRT was appointed as a discharging authority till the regular formation of appellate authority, at that time, even I make myself correct. A little confusion has arisen while I telling you appellate authority and regulatory authority. I want to bring to your notice that after enactment of Rera, within 6 months, it's government duty to appoint authority. Suppose there is a delay, then what to do? Act is enacted, it has come into force, then who will be handling the matter till regular authority is appointed? Then secretary can be appointed as a housing, secretary of housing can be appointed as a regulatory authority, that is Rera authority. He is a single member, he can work singly. So in that way, the work of authority can be done by secretary of housing, but at the same time, this type of work would have also been assigned to designated regulatory another authority. We have some other authority under Electricity Act, under I think Irrigation Act, that is water resource or like that. So this is one occasion where you are required to appoint secretary of the housing department to act as a regulatory authority and everything, because section further says that the complaints pending before such secretary of the housing department shall stand transferred to regular authority appointed by the government later on. So in that circumstance, it is acceptable, single man will be doing. Then why not here? And another occasion is that government is having power under section, I think 82, to supersede the authority for up to 6 months. Then what to do if the authority is superseded? Then it says that any person as a president or governor can exercise the powers of such authority which has been superseded. So he is also single member then in that occasion. So these two provisions are there to show that single member also can act and exercise the judicial power. So in that way, I had given some different reasons for that purpose. And one more reason which is practicable for appointment of Rera, chairperson and 2 full-time members are there. Qualification of members is given under the Act. I think there are 14, 15 or 16 categories which provide eligibility for appointment as a member. There is no compulsion that one should be judge. There is no such compulsion. And this issue was raised in Nilkamal. But Honorable Bombay High Court also said that no, nothing doing. We cannot say that it should be a judicial member. Judicial member is only appellate tribunal. And there one condition that even that National Judicial Service, any officer at a secretary level can be taken into consideration for judicial member. That was quashed. From anybody from Mantralaya cadre to the judicial member post. In that way, it was quite separated and designated. So one more nicety is that government authority may consist of chairman and 2 members, the minimum 2 members. It may be 3, 4, 5, 6, depending upon the requirement or depending upon the decision of the government. Suppose 7 members are appointed from 7 different fields: science, environmental, then art, and then sport, and like that, and technical, etc., etc. Are you expect that 7 members should always sit together for deciding a single complaint before Rera? Practically, is it possible? So in all this way, single member can discharge, and that is finally held. And I will again go. Regulations are there. to carry out the purpose of the act. Our regulation 24 is there. It clearly says that, yes, power is there to direct single member to hear the complaints, and such power can be exercised by regulatory authority. I remember one thing. When one matter was there before us, then the question before us was bindingness of the decision of the Punjab and Haryana High Court, because that was the only decision available, prevailing on that day to give the guidance. And in that way, but I found that it's a Punjab and Haryana High Court, not Honorable Bombay High Court, within whose jurisdiction we are working in Maharashtra state. And that I observed that what we can say, binding precedent and persuasive precedent. So persuasive was the nature of that decision, and it is not binding. And that's why we can give our own verdict on that decision. And in that way, we decided the matter accordingly. Then friends, I think my time is almost over. We will finish within 5 minutes only, because I do not want to take much time. It's almost, I think, more than 30 minutes. Nilesh ji, should I stop here then? And you should make me to stop, otherwise I will go on speaking and speaking. Just let me refer to 2 more points and then I stop. I will invite your attention to 2 core aspects under the Rera. You people are there. Think over this. In redevelopment project, member of old society is not recognized as a allottee. I have decided one matter and said that yes, that member is also allottee. I have given so many reasons for that finding, but it was a dissenting judgment. And we refer the matter to the office. I do not know what happened to the matter thereafter, but still I am waiting from the decision of Honorable highest court, on the issue that whether he should be what we can old member of the secretary or not. And another point, I had given one that judgment, that Milan Patkar versus Ruparel Estate on 3rd March 2021. And that another issue, that is the registration of Rera. Exemptions are there. 500 square meter area or 8 apartments. I said that considering object, considering legislation intention, considering the need of the Rera, it is not, though it is mentioned as or, it is to be read as and. Both conditions should be satisfied, because that matter before myself was such a that in Pune, suppose a building is being constructed in Sadashiv area, prime local area, highest price. How they will be getting 1 acre, 2 acre, 5 acre, and 5 guntas and like that? Hardly they will be getting some small piece of land. And still thereon they are constructing 22 floors building, consisting of 22 flats and 7 shops. What difference you can make? So in that way, I have said that no. That, and I've now rightly the matter is before Honorable Bombay High Court. Let us wait and let us see what happened to that. And last but not the least, that is the condition of depositing 100% amount under section 43(5). Rarely I confess before you right now that right from the beginning, I was definitely knowing that this is a provision 100% total amount, and only penalty is governed by the percentage. Frankly, I admit with you that it may be harassment, or it may be rather difficult, or it may be rather very, what we can say, financially not possible for the builders to come in the appeal. And why not to take some reasonable, acceptable view? And in that way we started. I know after 4 or 6 months, one party had raised this issue before me. They said that, sir, they ought to deposit. But you see, this point is already there in my mind. I was in the habit of suo motu referring some provisions to the advocates appearing before me. I used to say that, what is your opinion? Please tell me. Because the interpretation of this matter is like this. That is what I feel. And on that provision, many times I got the response that, sir, what you are saying appears to be correct. Then I said, read it carefully then. But we deliberately ignore to implement that provision. Finally, one matter, we were compulsory required to decide that issue. Application was made, arguments were heard. We also warned them that, you see, this is the first application. Occasion was there previously, but we had ignored it, and parties also similarly withdraw their application. But this application we decided, and I have mentioned that 100% deposit is required as far as amount is concerned. For this purpose, I will refer to this judgment, latest landmark judgment. I will simply point out this issue, 43.5, constitutional validness, is already observed that this is constitutionally valid. But while making this observation, the first paragraph, you please read carefully. Their lordships have categorically observed first part, penalty pertaining to 30%. They stopped. Full stop is there. Another part, refund interest and compensation, if any. What else is required for you? Are you waiting for a decision? Another? How can it said be to be a judicial approach then? No, I am doubtful then. This is sufficient. You cannot say that this was not the issue before the Honorable Vice Court. Some issues are, what we can say, hidden in that issue. Leading should not be asked. Means what? Your question should not be pregnant with the answer. This is an issue which is pregnant itself with another issue. You get the answer of two. You just carefully apply the mind and find out the correct approach. So this is what it is. And I think, Mr. Gala, I should stop, but just I cannot restrain myself to point out one thing. There are many matters or some matters, not many, which are already pending before the NCLT also. I think that we should go carefully through the pioneer judgment that Insolvency and Bankruptcy Act Code and Rera, both are Justice Nariman sir defined that aspect. So what I got from that, you please read para 28. They have clearly mentioned that both acts are working in different spheres. They are not what we can say overriding each other. If a conflict is there, they have said that code will prevail. But do you feel that anybody appearing before you for seeking relief under Rera is having some conflicting case before the NCLT also? Because what NCLT is going to do? They are going to decide the management of the company, competency of the to protect the company in that sense. We want relief against the creditor. That is why we. But I will simply suggest you to carefully go through the provisions, because what happens? Cannot we say that unless we have some proper approach? Is it not delay in delaying the justice? Then can we say that this is the best way for builder to shield away, to run away from the proceedings of Rera, just to tell somebody to file NCLT 1 petition and keep mum, because this will automatically stop? Think over this. No justice will be given earlier. People approach to Rera, approach is framed only for giving earlier justice also. Special machinery is framed. But still I will invite your attention to one thing. Introspect yourself. Consumer Forum Act is there since years together. You are referring the decisions of the Honorable Supreme Courts, which are based only on the basis of Consumer Forum Act decision. National Consumer Forum, whatever decisions were there, they are again challenged in the Supreme Court, and then we are saying that what flat purchaser can get this and builder cannot get this. We are guided by that only. That was the only provision available to the authorities. Rera came, no doubt. Ashwinji pointed out one provision that matter pending before the Consumer Forum can be withdrawn and filed here. Before me, not a single matter. I saw that it has come from Consumer Forum. Then for what purpose Rera is created? What is the fault? Why that matter is not being transferred to me? If the Rera is so sound and so justifiable, think over this. So one area of search, how many matters are withdrawn from Consumer Forum? Second search, what was the flow of institution before Consumer Forum? And after Rera, what was the flow before Consumer Forum? People are not interested in verdict only. They should get the fruit. Otherwise, it's very difficult to say that the object and purpose of the particular special act is achieved in a true spirit. True spirit means people should say that we are satisfied and we are getting everything. Thank you very much, Nilesh ji, Ashwin ji, and Satish ji.
Yeah.
I think I have taken much time.
Thank you,
I
sir.
have taken much time.
Sir, we will keep
No,
these
no, no,
5
no.
points in mind. Sir has suggested 5 points which are very important and pending. These issues have not been decided by higher courts. One which I note is the old tenant or a member of a redevelopment where he comes to claim his rent or any other right under the agreement. Shri retired member Sir Kole sir has decided in favor in dissenting judgment, as well as in the matter of Gitanjali, where issue of 500 square meter and 8 tenements have been decided. And I remember while I was arguing Zain Khan matter, and in the open court before the full bench, sir had encouraged and said that Galaji, I am with your arguments. I remember those days. As well as if Professor remembers the first matter where the issue of authority and powers of the AO in the matter of sea princess.
Correct.
Where Professor had remanded the matter to the AO, but the minute sir realized that the authority had powers which is interpreted in Pankaj Agarwal, sir had suo moto rectified that order. Is that correct?
Yes, yes.
That was the first matter.
I remember that day because it might have having what we can say huge effect.
The impact was very devastating, and all matters would have come to.
Yeah. And I know. I will not forget that day.
And so, sir, Supreme Court, out of 5 issues.
What I just Nilesh ji, I will not take. I will hardly 1 minute, one suggestion only.
Yes, sir. Yes, sir.
As far as that point is concerned, that is allotee. Old society member is also allotee, because finally he is also the member of the final society which is going to be formed. He is also entitled for all the other amenities which are given in the project, except that agreement for purchase or sale is not there. He is equally having all the rights as far as that project is concerned. That is what I want to say. Then how you can separate allotee entitled for 2 reliefs, allotee entitled for only 3 reliefs? What is this? How we can differentiate them? After all, you are going to form their society, equal footing in all the respect. Then why to form such society? Why not the society of old members another? Why not the society of new members another? There you want to them bring together to them. And where is the concept of this registration and status of allotee promoter when you will be filing complaints in future under section 12 and 14 for relief of compensation only? Till that time project is over, CC is also given. 5 साल में हमको डिफेक्ट मिला, चलो लगा दो मैटर. डिफेक्टिव टाइटल आफ्टर 15 years फाइल मैटर. वहां बोल सकते क्या ऐसा? तो फिर वो अलॉटी है क्या? नहीं. तो फिर वो सोसाइटी का मेंबर क्यों नहीं अलॉटी? उसको बोलने का नहीं, यू डोंट कम अंडर रेरा. ओके, दिस इज व्हाट माय
Thank you for your
probably I might have spontaneously
precious time, sir. And our treasurer, Mr. Aditya, will facilitate and give few words of vote of thanks.
Yeah.
I will request Mr. Aditya to.
Nilesh ji, just before that, I will say that once I started, I also do not correctly say
Sir, we
that.
enjoy your presence and sir, the
I let me clear that I spontaneously said, opine whatever there is in my mind, and take that these are all my personal opinions, but with
thank you very much. Thank you very much, Koleji. So now I will request our treasurer, C. Aditya Jantiye,
okay.
to prepare to offer the well-deserved vote of thanks. Aditya?
Yes, sir. Yes, sir.
Yeah, Aditya.
Respected Kole sir, thank you very much for gracing our today's session. We are so much obliged and we have honored to have you here, and you really enlighten everyone, each one present here, and your presence is very special because we have seen you in the courts, and we have learned a lot of things from you. So it is really an honor for us to have a good session from you. So it is really wonderful to have you here. Thank you very much for accepting our invitation and gracing the event today. Thank you very much.
Thank you very much.
Thank you, sir.
And again say that sorry if any statement this way or that way hurting anybody.
no, sir.
Very sorry. Huh? And Satish ji, how are you?
Fine, sir. Thank you,
अरे
sir.
क्या
We have been missing you a lot, sir.
Sir,
I have not.
I am enjoying your smile. I was enjoying your smile.
तुम्हारा आवाज सुना नहीं, इसलिए मैंने आपको बोलने को बोला कि अरे सतीश जी से हमको बातचीत करने दो अभी. अच्छा हुआ, चलो.
आपकी स्माइल सर मुझे वही याद था.
अश्विन जी, थैंक यू वेरी मच.
Thank you, sir. Thank you.
ओके, आपका बहुत प्रेम है, ऐसा ही रहने दो. हम तो हमेशा साथ है.
Yes, yes.
So also we request the same support from you.
So whenever, sir, we feel we require your presence, we'll certainly call upon you.
जी. Thank you.
Thank you, sir.
Sir, 2 minutes. Sir, 2 minutes. We will just take a photo, please.
Yeah. So everyone, please.
On your
you
videos.
can have on your videos.
Yeah, please.
All participants request you to on the videos.
Yeah, Aditya, now you can.
Okay. Yes, sir. Thank you.
Thank you, sir.
Thank you.
We will continue our question answer session, sir. Now, sir, you may.
जी, you please go. My best wishes to your webinar. Huh? Thank you.
Thank you.
Permit me to leave the chair.
Yes, sir.
Yes.
Thank you.
So, friends, now we have our speaker, Advocate Satish Dedhia and Advocate Nilesh Gala, to take over from here and discuss the 5 issues of the recent Supreme Court judgment. So, now I hand over to both the speaker. They may decide how to go about it.
सतीश जी,
एक मिनट नीलेश भाई, आदित्य
Yeah.
स्क्रीन शेयर करना.
Okay, I will make you done, sir.
नीलेश भाई, you please start.
Out of the 5 issues, I think the 3 issues were already decided by our Rera Appellate Tribunal. We were fortunate enough to be a part of that tribunal and practicing here. The Supreme Court has decided 5 core issues on legal aspects. The first being whether the act is retroactive or retrospective in nature. Whether the authority or the adjudicating officer will have exclusive power under section 12, 14, 18 and 19 to grant refund along with interest, or the jurisdiction exclusively lies with the AO under section 71. The issue number 3 is whether the power, a single member in the authority can sit singly and decide powers, and whether authority can delegate under section 81 for a single member to decide matters before them. The fourth issue was whether the condition of pre-deposit under proviso to section 43 for entertaining substantive right of appeal is sustainable in law. And the fifth issue is whether authority has power to issue recovery certificate for recovery of principal amount under 41. Now, out of these 5 issues, how this matter went up to the Supreme Court, the genesis of the matter started from Punjab and Haryana High Court in the matter of Janta lands, where this Punjab and Haryana High Court decided matter in favor of a promoter, deciding that a single member bench of authority could not have decided any matters, as the composition as required under section 21 requires 3 full-time members to be part of an authority deciding these matters. Satish ji, could you just throw light on Janta lands?
Nilesh bhai, screen sharing is not possible, I think.
Sir, what I may request is, Aditya, if you can just make Satish ji as a co-host.
Sir, already done. 2 minutes.
Satish bhai, you're a co-host now.
Is the screen visible?
Yes.
Sir, in Janta land developer, similar issue was raised that the single member of the authority cannot decide the complaints filed by the allottees under section 31 for the reliefs under section 12, 14, 18 and 19. So that issue was challenged, and in Janta land, the Honorable Punjab and Haryana High Court held that single member cannot decide the issue, and therefore that matter was challenged before the Supreme Court. And before that, Honorable Supreme Court has decided this Newtech promoter's judgment and has finally settled the issue. Nilesh bhai.
In this Supreme Court matter before which is the topic in today's webinar, what are the rights which are confirmed in favor of an allottee? Satish bhai has really worked hard on the presentation today to show that a complaint lies under section 18 once the date of possession as promised in the agreement. has expired, the right under section 18 becomes unqualified. And those paragraphs Satish Bhai has highlighted. Satish Bhai, I want you to throw light on this, what Supreme Court has said in this Newtech judgment.
Yeah, we are seeing the screen. Honorable Supreme Court has held at different paragraph, and the screen is on uh, the slide is on the screen. Honorable Supreme Court held at para 25 that the right under section 18(1) and 19(4) are not dependent on any contingency or stipulations thereof. And it also held that the rights under 18(1), that is to claim refund, as well as if allottee wants to continue in the project, then claim interest for the delay. And this right is unqualified, unconditional, and absolute right. Also, it held that the right is undefeasible. And why unqualified right? The explanation is given that the language of section 18 is so clear with the four words used. Number one, failure, inability, discontinuance of business, and any other reason. So, legislature has already covered all this by these four words, that whether delay is caused due to failure of the developer or inability due to any reasons. It can be said as the mitigating circumstances, reasons beyond control, and so on. Or even if the business of the promoter is discontinued, or if there are any other reasons, say Corona or COVID 2019. So all these reasons are covered with these four words, and Honorable Supreme Court has again held that the rights under Section 18(1) are not dependent on any of these conditions, because the explanation is given subsequent paragraph, because for all these reasons allottee is not responsible, and therefore when the allottee is not responsible for all these reasons, the promoter has to give interest for the delay period, or if allottee wants to take refund or withdraw from the project, then promoter has to refund the amount received from the allottee along with interest. So with this clarification, this issue of section 18(1) is completely now settled, that under section 18(1), the interest is allottee is entitled to claim interest right from the date mentioned in the agreement as possession date, and from that date the allottee is entitled to claim interest irrespective of the reasons that may be given by the promoter to justify delay, and irrespective of that reason the allottee will get interest for the delay period, or in case of refund allottee will be entitled to claim refund from the date of payment. Nilesh bhai.
Satish Bhai, if I understood very clearly what you have interpreted, or the judgment as it reads, says that this right is an unqualified, unconditional, and absolute right. The minute
Correct.
an allottee invokes section 18(1) and he chooses either not the proviso seeking refund or chooses interest for delay, this right, is there any scope for any judicial interpretation after this order? Satish Bhai, can you throw some light on this?
After this judgment, there is no reason left for judicial interpretation of the section 18(1), because in the Nilkamal judgment also, and in other judgments of Supreme Court also, section 18(1) has been already defined and analyzed in detail, and therefore now no scope remains for the authority to go for seeking interpretation and analyzing the reasons, or giving its reasons in a different way just to enable the promoter to get any relaxation in the liability imposed under section 18. So now authority has very limited scope, that we will see in the later screens, that now the authority has very limited scope on section 18(1), and he has authority member has to grant interest from the date mentioned as possession date in the agreement.
Satish Bhai, what is the other core issues decided by the Supreme Court in this matter which you want to throw light, and which is decided and the authority will have no room or scope to
Nilesh bhai,
interpret after this order,
we will
or
start
the
from
appellate.
the we will start from the interpretation given by the Honorable Supreme Court. The Honorable Supreme Court has given the three different type of principles, mentioned three different type of principles in this judgment. Number one at para 85, that how to interpret and apply Rera uh, by the authority. It says at para
May I
85.
read? May I read? Para 85, the provisions of which a detailed reference has been made. If we go with the literal rule of interpretation, that when the words of the statute are clear, plain, unambiguous, the courts are bound to give effect to the meaning regardless of its consequences. What do you mean by this, Satish bhai? Regardless of any consequences, the courts are bound to give the meaning to its literal sense. Does that mean that once Section 18 is invoked, allotee is entitled to refund with interest as proviso gives them that right, and delayed interest if they invoke 18.1?
Yes. Uh, Senior counsel Kapil Sibal has raised an objection in this case that the refund in case of the and in present circumstances, refund is not in the interest of the project, and therefore he objected that the refund right of refund shall be qualified. And so, and like other issues, he also objected that the agreements which are already executed before implementation of RERA, that is before the 2016 or before implementation 1st May 2017, whatever agreements have been executed by the promoter in favor of allottees by way of section 18, all these agreements are getting changed because the right given under section 18 to the allottee is a new right. Prior to that, this right was not given under MOFA or any other statute. And therefore, senior advocate argued that this right shall be qualified and conditional. Like there are several other issues that if the authority gets sympathized with the developer, and hence the court has held that authority has to apply the law which is given under section 18 as it is in the simple and literal manner, and the court or authority has to give effect to that meaning. That means to give interest from the date mentioned in the agreement as a possession date, or refund from the date mentioned from the date of payment. So irrelevant the consequences or the impact of this decision shall not be considered by the authority while giving the decision under section 18 on the complaint filed by aggrieved allottee. So in that sense, Honorable Supreme Court has held that regardless of consequences, means whatever the consequences be on the project, whether the promoter is financially well or not, whether the project will get affected or not, if the rights given under section 18 to allottee are exercised, then the authority has to give uh, result or order in the same manner as interpreted or as given by the simple words used in section 18. Nilesh
So,
bhai.
Satish bhai, the one question which arises to everyone, including me, if there is a court stay order or a lockdown, or because of pandemic that the construction work could not have been carried out, whether still this interpretation stands good in this judgment, has that been discussed?
Yes. In this judgment itself, Honorable Supreme Court has held that if the reasons, even because of the stay order of the court for any reason, if that reason is not attributable to the allottee, then promoter has to give interest for the delay period. So for example, if any PIL has been filed for which promoter is not responsible, then or say for example COVID lockdown is are imposed for which promoter is not responsible. In that sense, the Honorable Supreme Court says that if the allottee is not responsible because all the obligations imposed on the promoter under section 11 to obtain the approvals and to complete the project and comply with the terms of approvals are imposed on the promoter and not on the allottee, and therefore the allottee cannot be held responsible to share the burden of delay by accepting lesser interest or for the interest for the lesser period. And in that sense, Honorable Supreme Court has held that if the reasons of delay are not attributable to the allottee, then promoter has to give interest from the date mentioned in the agreement as an possession date.
Can we go to the next slide, Satish bhai?
Yeah. Nilesh, my next slide is regarding the retrospective or retroactive nature of Rera Act and the impact on the decision.
Important conclusions of Supreme Court in the Newtech judgment as far as the issue which was concerning whether the date of possession or the agreement which are executed prior to Rera coming into force can be given effect before Rera authority. There were conflicting orders passed by the Rera authority, which came to now rest because of the issue which is decided by the Supreme Court. There were submissions made by the senior counsels appearing for the promoters there that any agreement which was executed prior to Rera should not be given effect under Rera, and the obligation therefore should not be cast upon the promoter once Rera is imposed and a new date of possession as agreed and registered before Rera should be given effect to. Now this judgment also by an allottee's advocate had relied upon an earlier judgment of Supreme Court in the matter of Imperia. Correct me if I am wrong, Mr. Satish bhai. Imperia structures categorically stated that the date of possession in the agreement has to be considered while passing an order for interest, refund or penalty under section 12, 14, 18 and 19, and not the date of registration as given in Rera. That is the interpretation by the Supreme Court, which is also reiterated in the present judgment. Therefore, the Supreme Court has held, as held in the Nilkamal judgment by the Bombay High Court, clearly interpreting that the provisions of Rera are retroactive in nature, giving wider scope to the authorities. Satish, could you throw some light on Imperia structures along thread with the Newtech judgment?
Nilesh Bhai has referred the Imperia judgment. In Imperia Structures Limited versus Anil Patni, Honorable Supreme Court has decided on two issues. Number one, that when the promoter claims that it has mentioned a different date while registering the project with Rera authorities, then the interest shall be calculated from the date mentioned in the आदित्य जी बाकी के जरा आप म्यूट कीजिए ना.
Yes, sir. एक minute.
Mark Singh ji, please आपको म्यूट कीजिए.
Done, sir. Done. दिया.
So in Imperia Structures judgment at para 31, Supreme Court held that the merely because the registration under the Rera Act is valid till so and so date does not mean that the entitlement of the concerned allottee to maintain an action stands deferred, or it is relevant to note that even for that purpose, the period has to be reckoned in terms of agreement and not from the date of registration. The reason is already explained by Honorable High Court in Nilkamal judgment at para 256 that the relaxation was given to the promoters because Rera was implemented for the first time. So all the ongoing incomplete projects are given an one-time relaxation that they can define or decide the completion period for the remaining work as per their discretion and mention that date in the project web page while registering the project. but that does not mean that the possession date mentioned in the agreement is got rewritten, because the Rera authorities or the parties have no right to rewrite the document or with the terms already agreed between the parties regarding the possession date. So that was the followed in the imperial judge structures also, that interest period under the section 18 has to be calculated from the date possession date agreed between the parties and not from the date mentioned in the project web page while registering the project or extended date. Both data are given for the separate purpose. Both these data are given for the purpose of obtaining further extension if the project gets it remain incomplete before the registration date expires. So purpose of that date are totally different, and that defense cannot be taken by the promoter while defending the complaint filed under section 18 for claiming interest under the for the delay period. Honorable
Satish bhai,
Supreme Court.
Satish bhai, very interestingly, I'm sorry to interrupt, you have shared the judgment of Western developers also, which has said that even the grace period is not a matter of right.
Correct.
So apart from the date of possession, even the grace period, this High Court has held that it's not a matter of right, and promoter has to make out the case to delay caused in handing over possession. So even the grace period mentioned is not given discount off to the promoter. Why is that so? And can you read in conjunction with Western and Imperial, what is the interpretation which Bombay High Court has held in that?
Sir, for that we have to understand two words given in section 18(1). Number one, the reason is words used are failure, and number two, inability. From that two words, the liability of the promoter gets defined for the delay period. So if the project is delayed due to failure of the project, that is inability of the promoter is a different thing. But because of the failure means negligent on account of the promoter, then also promoter is liable. And even if the promoter is unable for the reasons that not directly attributable to the promoter, the reasons which are not in control, or the reasons which are beyond his control, or mitigating circumstances, or whatever other names are called, for all such reasons, if the project gets delayed, then also, because of these words used in section 18(1)(a), promoter has to give interest for the delay period from the agreed date of possession. And for this reason, the force measure or reasons that were beyond control as allowed under section 8 of MOFA are now not allowed under section 18(1) of Rera. And for this reason, Honorable Supreme Court in Imperial judgment held that uh, on reading section 79 of LOT describing the stated in paragraph 22 would stand barred from invoking jurisdiction of civil court. However, while interpreting along with the lines of section 89 88, the parliamentary intent is clear that a choice, sorry, this is in regarding to consumer court. In Western developer of Bombay High Court has held at para 3 that clause providing grace period should not be given as a ad hoc measures by the authority while deciding the judgment, because the promoter has to justify as per the Neil Kamal judgment para 126 that the attempts he made attempts for completing the project, and still thereafter he failed to complete the project. And in that sense, Western developers in High Court, Honorable High Court has held that the just because the promoter has mentioned or inserted a clause providing grace period for to itself will not be sufficient to allow the authority to give any relaxation to the promoter. But now, in view of judgment passed by Honorable Supreme Court in Newtech judgments, this decision also will not be helpful to the promoter, because irrespective of the reason that caused delay, the promoter has to give interest for the delay period to the aggrieved allotee. So now this judgment also will not be helpful to the promoters to get any relaxation in liability imposed under section 18(1). Nilesh bhai.
Satish bhai, we will be taking question answers in 15 minutes from the members which have joined. Before that, I would like to cover up the entire slides. Can you first go to the slides which are awaited to be shown on the screen, Satish bhai?
So we will start from the retroactive slide,
Correct.
Nilesh bhai.
Yes.
Yeah, this slide is on screen.
Yes. The conclusion drawn in the Newtech in para 41 is very clear that the Supreme Court has held that the provisions of the Rera are retroactive in nature. The submissions are summarized and the reasons which are given are explained in paragraph 32, 39, 41, 45, 48. Those are marked in the slide. The distinction made between retrospective and retroactive nature is also made in para 48 and 50 and 51. And clarification that RERA will apply after registration of project is also given in para 37 and 54. In this, Satish bhai, quickly, I want the distinguishment between what is the Supreme Court held in Newtech judgment, what is the distinguish drawn between retrospective and retroactive nature in para 48, 50 and 51, and also the clarification that RERA will apply after registration of projects in para 37.
Yeah. Sir, retroactive nature by Honorable Supreme Court has held that the certain provisions in RERA, including Section 18, are retroactive in nature. That means all the projects which are incomplete as on date of implementation of RERA, and if completion certificate is not obtained in that project, then that project has to be registered with RERA authorities. And in that sense, all the provisions of RERA will be applicable to that project. And so the aggrieved allottees can file complaints for their grievances against the promoter for that reasons given as per the section provisions of 12, 14, 18, 19 and so on. So if the retroactive, if the law was not retroactive, then the ongoing incomplete projects would not have been compelled to register with RERA authorities. And therefore, Section 3 has specifically mentioned that all the ongoing and incomplete projects have to be registered. And only exception has been given as explained by our Justice Sri Skole sir in Gitanjali judgment, that if the project is not exempted, and Honorable Supreme Court also says that only those projects which are exempted under Section 32 need not required to be registered with RERA authorities, and all other projects which are incomplete and wherein the completion certificate has not been issued, then that project should be registered with the RERA authorities. And so impact of this Newtech judgment on all the incomplete projects are such that such projects now required to be registered with the RERA authorities. In Mohammed Jain case also, almost similar decision was given on this line that if the project is not registered and if it is incomplete, then RERA authority can give direction to the RERA authority to the promoter to get register that project with RERA authority within a specific time, or authority can impose penalty on such projects. So impact of this judgment, we have to look in the sense that this issue is now finally settled at the topmost court, and therefore all the incomplete projects have to be registered. But the condition is that given in the section in para 37 by Honorable Supreme Court, that even in case of incomplete and ongoing projects, the provisions of RERA will apply only after the project is registered with RERA authorities. So at that time, the judgment of Mohammed Jain in by Honorable Bombay High Court will be help to the aggrieved allottees for such projects. Number two, the retroactive nature is already explained that all the existing agreements executed by the promoter in favor of the allottee before the implementation of RERA in incomplete and ongoing projects, the new rights available under RERA, particularly under 18, Section 18, 13 and 12 will now be applicable to those projects also. So this judgment on retroactive and retrospective will also help to those allottees whose agreements have been executed prior to implementation of RERA, and so these words will helpful to those allottees also. And so the allottees will be entitled to raise claims for all such grievances which were arisen prior to implementation of RERA. And for that reason only, Section 71(3) says that all the pending complaints before the Consumer Court now can be transferred to the RERA authority. So retroactive nature will help all these allottees of incomplete and ongoing projects. Nilesh bhai.
Satish bhai, can we move to the next slide?
Yes.
So the impact of the decision on incomplete projects. This aspect also has been touched upon, although there was no issue which was to be decided. But what is the judgment ruling on the incomplete projects which the Supreme Court has come to a conclusion that all ongoing projects wherein CC are not issued as on so and so, all future projects shall be registered with RERA authorities, only projects exempted under so and so, as also Kole sir has interpreted or said in Gitanjali's judgment, and projects wherein completion certificates are not issued and which are not ongoing, no further development is to be carried out, will not require to be registered. Can you throw some light in red with the Zen Khan matter?
Kya Nilesh bhai?
Satish bhai, in this slide, you have said that the Supreme Court in Newtech judgment also has interpreted that the Act will be applicable to those ongoing or future projects. Can you throw some light on this aspect as well?
We have already discussed that the all in ongoing and incomplete project have to be now registered with RERA authorities, and all the future projects, it obviously, which are now commenced after 1st May 2017, have to be registered with the RERA authorities, except if those projects are not coming under the exception given under Section 3(2) of RERA. Otherwise, all the projects, but condition is that the completion certificate should not have been obtained, and number two, the project should be incomplete. So if the project is already completed and nothing remained to be developed, or promoter is not going to put up any additional construction, then he may not require to register with RERA authority as per this interpretation.
So coming to the next slide. Why interest of allottees needs to be protected, as Supreme Court has given reasons that the object is not as interpreted by the authority, that a balance needs to be struck. And the Supreme Court has said that no, there is an imbalance which needs to be brought in, and a allottee is not in the same capacity as a promoter. What is Supreme Court in Newtech has held?
Yeah, Nilesh bhai. The Supreme Court has held that the interest of the allottees should be protected in the context of Section 18(1), and in the main issue that whether authority or the AO should decide the matter. In that context, basis of the submissions made by the respective councils, Honorable Supreme Court held that as per the objectives mentioned in the preamble of RERA itself, one of the project, one of the main objective of RERA is to protect the interest of consumers in the real estate sector, and for that reason also, the court has to decide the matters accordingly. Number two, another object of the RERA is to maintain transparency and bring accountability in the real estate sector, and for that reason, the promoter has to make disclosures from time to time and upload all the documents from time to time and give information to the allottees and so on. Supreme Court has also held in context of NCLT judgments that now, as per the amendments in the Insolvency Act also, Parliament has held that the allottees are financial creditors, and therefore also because the allottees obtain loan from the different institutions and pay to the promoter so that the promoter get finance to complete the project. So allottee has now dual role. One, he pays for the purchasing the flat, as well as he is financing the incomplete projects. So promoter is getting finance at very lower interest rates as compared to the interest rate applicable to the loans obtained by the promoter on commercial basis. So here the position of the allottee is such that his flat is also stuck and his money are also stuck with the promoter. So for in case of delay, the promoter has to compensate the allottee, and thereby the imbalance created due to the evil practices committed by the promoter are now get balanced by way of section 18 by allowing interest for the delay period to the aggrieved allottee as per section 18. And the next reason given by the Supreme Court is that the rights of and duties of the allottee as well as promoter are well defined under the different provisions of Rera. For example, only liability of the allottee is to pay balance installments and take possession and comply with the remaining conditions of the agreement as per the provisions of Act. Whereas the various obligations are imposed on the promoter, right from registering the project, disclosures, completing the project, obtaining approvals, complying with the terms of conditions, and so on. So the obligation on promoter are more as compared to the obligation of the promoter, and therefore also the right of allottee has to be protected. So in this context, Honorable Supreme Court has held that considering the prevailing evil practices and considering the weakest stakeholder position of the allottee, the rights of the allottee need to be protected.
They
Nilesh bhai.
have also said they have also said that they are not equal. The rights and duties, obligation of promoter and allottees, they don't stand in the par. Allottee is a weaker section, and therefore their rights needs to be protected. A very well interpreted and said in which is rescuing all the allottees from the sharks. Next paragraph, next slide. Rights of allottee under section 81 as Supreme Court has decided in Newtech. The points which are considered is 18.1 and 19.4 are not independent, and any contingencies stipulations thereof. This has been already widely discussed by the Honorable Chief Guest Speaker today, Mr. Kole. Also, Mr. Dedhia has thrown some light. Satish bhai, can you just quickly run through this? Satish bhai, you're on mute.
There are many cases wherein the authority has given relaxation to the various promoters in liability under section 18 on basis of various reasons. Now, all these reasons are now available with the promoters because of this judgment and interpretation that the conditions imposed on the promoter under section 18 and rights given to the allottees are totally not unqualified, unconditional, and absolute. And therefore, the promoter has now no ground to seek any relaxation. And also, the right under Section 18 of the allottee to claim interest or compensation are now not dependent on any contingencies or stipulations thereof. The reason is clear that as per the Supreme Court, the right under Section 18 is indefeasible. That means the not capable of being annulled or avoided or undone. And for these reasons, now the allottee will be simply get interest right from the date mentioned in the agreement or document as possession date, and from that date the allottee will be entitled to claim interest.
Can we move on to the next slide?
We have covered this,
So these judgments we have covered briefly. Can
except
we move
Bombay
to the
dying, except Bombay
yes,
dying.
Satish bhai, what is the relation which the Bombay High Court in Bombay dying, where I think our honorable speaker has delivered this judgment when sitting in the appellate tribunal, reversing the matter of, I'll just give a brief background, that allottees who, there were no agreements executed, and the honorable chairman of the Maharera authority said that once there is no agreement, that they cannot claim any reliefs, and therefore the provisions of the registration or the date in registration will be applicable. Those allottees had challenged by way of an appeal before the Maharera Appellate Tribunal, and our chief guest speaker had the occasion to decide and interpret law on this subject, which reversed the order of the Maharera authority and granted refund to the allottees. I believe the allottees, the flat unit size was around 10 crores, and the allottees were in 10, the applications were 10 in numbers. And the Honorable Maharera chairman, the ex-chairman, also has interpreted that if refund is granted in such a nature, the project will come to a doldrums. The appellate tribunal came to the rescue of these allottees by interpreting law as Supreme Court has said in its literal manner, and saying that irrespective and regardless of what are the consequences to the promoter, the right of an allottee as interpreted stands clear, unambiguous. Section 18 is unqualified. This Bombay dying judgment comes to the rescue, and the promoter had filed a second appeal in the Bombay High Court. Satish bhai, briefly, quickly, can you share some light on this?
So in the context of Section 18, Bombay High Court has held that if the agreement to be executed by the promoter is actually in context of Section 13, and in context of Section 18, that agreement is not at all required. So it means that the whatever document given by the promoter at the time of sale of the flat, like brochure, advertisement, or website, emails, or any other communication or allotment letter, will be considered as an agreement for deciding the liability of promoter under Section 18 to give interest for the delay period, or in case allottee wishes to withdraw from the project, then to give refund along with interest right from the date of payment. So in that sense, the Honorable High Court has distinguished that there are two different agreements as far as Rera is concerned. Therefore, Section 18, the agreement word used in the Section 18(1) is not the agreement which is to be executed by the promoter, and that agreement is to be read as per the context of Section 13 and not Section 18. So any document wherein the possession date is mentioned at the time of selling of the flat, and if that right is not waived clearly by the allottee, or if allottee has not given written specific extension and with clear waiver of his right regarding the delay, then that document will be helpful to the allottee to seek interest for the delay period or to seek refund with interest from the project. And for that reason, if even the formal agreement is not registered by the promoter in favor of the allottees, then here the Bombay High Court judgment, with the help of Newtech judgment, comes to the rescue of allottees, such allottees wherein the agreements are not executed. Nilesh bhai.
So can we move to the next slide?
Yeah. Impact.
So the impact of interpretation on complaints, first appeal, second appeal having claims under 18(1). If the promoter fails to give, this is the literal interpretation or the definition in the act. that the time stipulated in the agreement, regardless of unforeseen events or stay order. This is very important. The court has interpreted that even if there is a stay order from any court, tribunal, or authority which is not indirect or indirectly attributable, or the allotee is not involved in any sense to that stay order, then the promoter is under an obligation to refund an amount. This interpretation given by Supreme Court in light of the recent pandemic which has happened or occurred. So, would it also interpret that the pandemic lockdown or any stay order of any court on a project and an allotee wants to seek refund, there cannot be a different interpretation than what Supreme Court has held, that it is the right of an allotee to seek refund or interest on delayed possession. Is that correct?
Yes, sir. The reason for this interpretation by Supreme Court is that the rights and obligation of allotee and promoter are totally different. Completion of the project, and for that reason to obtain approvals and comply with the approvals relevant to the completion are imposed on the promoter and not on the allotee. So when allotee is not responsible for the any obligation to be discharged, why he should be penalized with the burden caused due to the delay for such reasons? And for in that context, Honorable Supreme Court has held rightly that if the reasons are not attributable to the allotee or home buyer, then the promoter has to pay interest for the delay period, because the as per the contract between the parties, the promoter has right to utilize the money of allotee till the date of possession mentioned in the document, whether it is agreement or any other document. So his right gets end on expiry of that date. So when that right and ends, so promoter is required to pay interest if he wants to utilize the same money, or otherwise the promoter has to give refund with interest. So for that reason, this interpretation has been given by the Supreme Court.
Can we move to the next slide? So quickly, in 10 minutes, we will start our question answer session.
Yeah.
The further impact of interpretation on the complaints, first appeal and second appeals, as far as the claim or a complaint under Section 18. The promoter, point number 1 is said in the slide, is promoter is not entitled to seek any relaxation in liability. That means that there cannot be any waiver granted by the authority while deciding a complaint of Section 18. Is that the interpretation? Promoter not entitled to seek any relaxation on the basis of COVID, and that cannot be attributable to the allotee. Promoter not elected. So these are the broad issues which we have already discussed. Quickly, Satish bhai, could you just throw light on this? Decision
Yes,
of jurisdiction. Now, this is a very important aspect, Satish bhai. Could you throw what the Supreme Court has held after Pankaj Agarwal of Rera Tribunal, and how this matter traveled up to Supreme Court? I'll just give a brief background. This issue was, as far as Section 21 is the interpretation of one, that Section 71 clearly stated that all complaints under Section 12, 14, 18, 19 are ought to be decided by an adjudicating officer. At the same time, Section 72 also said an inquiry has to be lodged for granting any interest or compensation thereof. Now, giving that interpretation by Bombay High Court in Marvel Sigma, the occasion of Supreme Court to decide was due to Janta lands and also the Newtech, where the issue was whether authority has the powers to decide violations of 12, 14, and 18 and 19, and only literal interpretation as it's given, that the part of compensation is concerned is to be divided by the adjudicating officer. And if there are overlapping prayers or a conjunct reading of both the prayers seeking interest as well as compensation, how the same has to be dealt with, the Supreme Court has decided. So, Satish Bhai, could you just throw some light on that?
On composite reliefs.
Correct.
So, as per Rera or any other act rules in the states that have adopted Rera, two different forms have been provided. In Maharashtra, Form A and B, and in UP, Form M and N. So, all complaints that are seeking refund or interest for the delay period has to be filed in Form A directly to the Marera authority. So that is the interpretation. Number two, if the allottee wants to seek any compensation for the losses caused as per the provisions of Section 12, 14, 18, and 19, then the allottee has to file separate complaint with the adjudicating officer. So in Pankaj Agarwal judgment, it has dealt with the complaints which have wherein both type of reliefs are combinedly seek in single complaint. So means that the interest has been also claimed and the compensation has been also claimed. The reason is explained at para 26 and 62 of Pankaj Agrawal judgment on basis of the principle of CPC that cause of action cannot be separated. And for that reason, a composite complaint, a complaint with multiple reliefs, which are to be decided by the authority and AO, can be filed in a single complaint. So, Honorable Supreme Court has now dealt and made it final that all new complaints have to be filed separately in separate form. For example, if the allottee is seeking interest or penalty for any contravention, then that complaint has to be filed in particular form for Maharashtra in Form A and for UP Form A M. So all these complaints have to be filed in only for those reliefs and have to be addressed to the authority only. And if complainant is seeking compensation under section 12, 14, 18, and 19, then only for limited the reliefs related to compensation has to be addressed to the AO as per section 71 and 72. So both the complaints have been separated. But what in if the existing complaints wherein the both complaints are sought in a single complaint, the Honorable Supreme Court has held that such complaints, if not decided, can be segregated at a appropriate stage. So appropriate stage will be the authority, wherein the authority will decide the complaints reliefs related to interest and then transfer the remaining part wherein the reliefs regarding the compensation have been sought, and to that extent he will transfer the complaint to the AO, and that thing has been already dealt with by Honorable Maharat in para 26 and 2062 in Pankaj Agarwal judgment. Nilesh bhai.
Can we move to the next slide?
Yeah.
So we have widely spoken about this issue of single member authority, as this technical objection was always raised. And when we were also appearing on the promoter side, section 21 was taken as a defense that composition requires 3-member bench in light of even the interpretation of 43 where the appellate tribunal bench also is to be constituted as 2-member bench. And the Bombay High Court had held that order passed by a single member of appellate tribunal cannot be good, and has remanded matters and said that it has to be decided by one judicial member and one technical member. This similar objection was raised by the promoter as far as authority is concerned. Supreme Court has given some good interpretation where it said that the delegation under 81 power of the authority is so wide that they can delegate the power on a single member to decide the functions of the authority. Just so quickly, can you in 1 minute summarize this, Mr.
Yeah. So Supreme Court has held that the authority has power to delegate its such of its functions and powers to any of the members of the authority, that is regulatory authority, and who can decide singly any complaint filed under section 31 on the complaints regarding violation or interest. So single member now can decide the such complaints. Honorable Supreme Court has also held that the objection that the section 21 says regarding the meetings and quorum are not applicable to these complaints, because those are related to the policy decisions have to be taken by the authority under section 32 to 33 and 34. So for those matters only, those complaints or applications have to be addressed to the authority, and it would be decided by the full bench of the authority with the quorum as per the rules. So this differentiation has been made by the Supreme Court, and with an object, the object is to achieve the main object of the Rera for speedy disposal and speedy grievance redressal. And for that reason, Honorable Supreme Court has upheld the UP Rera's decision to delegate its power to single member. Nilesh bhai.
Can we move to the next slide? The conclusions, I think we have also touched upon the other conclusions on authority of single member to decide the complaints. This has been briefly discussed and extensively discussed by the chief guest speaker as well as Satish bhai. Can we move to the other slide?
Yeah.
Decision of jurisdiction of AO on pending matters. What is the impact which really affects the matters pending before the AO? Satish bhai, this is a very important aspect, as AO may return the complaints, have claims for interest on 12, 18, 19 and so on back to the authority. Now all orders passed by AO for interest have become void, are null, and have to be remanded back to the authority. One question which arises is where a warrant is issued already in a matter where the authority has, the AO has decided a matter for interest and default. What happens to that? These are the questions which will come in the forthcoming time to be interpreted. What is your view, and whether Supreme Court has touched upon that?
Supreme Court has simply said that to segregate the complaints, and that decision is regarding the pending matters and not on the already decided matters. So we have anticipated few circumstances wherein the impact of the these Newtech judgments will decide the fate of the ultimate fate of the complaint. So if the complaint is pending now before the AO, then AO has to return back the complaint, and the authority will decide the matter. And if the already AO has passed the order and the matter is pending before the appellate tribunal, then appellate tribunal may revert back the matter back to the authority and to fresh hearing and decide the matters. If AO has passed the orders and appellate tribunal can also decide the matters freshly, we will discuss it in the next slide. So first appeals, if first appeals wherein the AO order is modified, then the impact will be that it will be get merged with the judgment passed by the appellate authority tribunal. So that orders will be saved. And the second appeals, which are now pending before High Court, wherein the orders are passed by the AO, and the orders are not set aside or simply set aside without any modification, then High Court may ask or return, may remand back the matters back to the lower authorities for fresh hearing. So the impact or this decision regarding the single member can handle the matters is like an earthquake on the all the pending matters, either different stages, whether it is before lower authority, appellate tribunal, or High Court. So all the affected matters will be affected. As far as the recovery, wherein the matters recovery warrants are issued on basis of the order of AO, then the promoter now may again go back to the Rera appellate authority or before the High Court, challenging that recovery warrant, and may ask to set aside or modify the as order and ask for the fresh hearing. So
Satish bhai,
ultimately, the
one question which comes to my light is that if there is an appeal pending against the order of AO, can the appellate tribunal under any provision decide that issue directly without going into the aspect of jurisdiction, or the remand is mandatory?
sir, we have dealt with in the next slide ki why remand should not be made on wholesale basis. So that
Okay.
we those points are discussed in the next slides. Uh, we have covered 3 to 4 judgments saying that the as per the provisions of section 24 and 25 read with order 41 of CPC, there is already a provision that if such orders wherein the merits of the matter are not affected, then honorable tribunal can freshly decide all such matters. And there is a mandate. In fact, there is a mandate in these judgments as well as in the provisions of CPC that appellate authority has to decide such matters afresh by giving opportunity to both the parties, including by allowing them to file additional documents. And the appellate authority should not remand back such matters to the lower authority. So at present, some matters are remanded back to the lower authority are not that judgments are not correct as per my view. Maybe because the advocates appearing for the parties have not taken any objections or have not prayed to the appellate tribunals that you can decide these complaints, the orders and appeals freshly as per the provisions of CPC 24, and the appellate authority has more experienced judicial persons available and with the authority. And when there are a lot of matters are pending with the lower authorities, when there is a minimum members are available with the authority, in such circumstances, it is a duty of appellate tribunal to decide such matters afresh without or
One
without
more
remanding.
question comes to my mind is whether CPC is applicable to Rera. I think this is a special statute. It has own rules and regulation. Whether it is bound by the provisions of CPC, is that the judgment of Delhi High Court in the matter of arbitration where CPC provisions were applicable, and even Arbitration Act where it clearly says that the rule of CPC and evidence is strictly not to be applied. But this judgment, will it come to the rescue in Rera as well?
Yes, sir. In case of Hero Wind Energy, Delhi High Court has held that proceedings under Section 9 of the Arbitration Act has a sense of urgency about it, and considering the same, it is not demand appropriate by us to shuttle the parties to and fro the branches of this code. The words used need to be read again, that the court does not want to shuttle the parties to and from the branches of this code. The principle of order 41 and rules 2433 read with
Can you
4122.
enlarge the screen? Can you enlarge the screen? Yes.
So this judgment is very important. All 3 4 judgments are very important and held that the appellate tribunal has to decide such matters, because the reason is simple, that just because of jurisdiction the matters are not merits of matter are not affected. The parties were aware of the issues in the matter, and parties have relied upon the documents and produced before the lower authority, in our case AO, and AO has given order on merits. Then such matters should not be remanded back by the appellate tribunal just because now Supreme Court has held that AO does not have power to decide the such complaints, seeking interest for the delay period or seeking refund with interest. So all such matters should not be remanded back as per these judgments, because as per the AO's appellate tribunal's judgments also, the principles of CPC are applicable as per the provisions under section 88 of Rera, that if the principles which are not covered in the Rera Act or rules, then those principles, if not inconsistent with the provisions of Rera, then principles of CPC has to be considered by appellate tribunal, and according to these principles, appellate tribunal has to decide such complaints afresh instead of remanding back and increasing the burden of the lower authority.
Satish bhai, can
Nilesh
we
bhai,
move
I will request that you give some more highlight on this point, because the impact of this judgment will be on such matters, and so unnecessary hundreds of appellates
cases will be
appellates
remanded?
who are,
Correct.
yeah.
Thank you, Satish bhai. I'll quickly summarize this Delhi High Court judgment, which was by a single judge of the Delhi High Court judgment rejecting the reliefs under Section 9 on jurisdiction aspect of arbitration, that when one agreement where there is an arbitration clause cannot be invoked twice. The single judge of the Delhi Honorable Delhi High Court has rejected the reliefs under Section 9, saying that you cannot knock the door of the court invoking same agreement twice. That came to be challenged in an appeal. The appellate tribunal, appellate judge, the division bench of the Delhi High Court, two-member bench, decided in favor of the appellate and saying that legal interpretation of that arbitration act said that one agreement can be invoked n number of times for different breaches. But they did not remand the matter back on that technical issue and decided the matter on its merits by themselves, as the fundamental principles of Order 41, Rule 24 and 33 empowers the appellate tribunal or the appellate court to proceed to decide the matter on merits, even if not decided by them. Therefore, keeping this as a precedent in the issues where the matters before the honorable tribunals are pending, where the AO has decided those complaints of section 12, 14, 18, and in light of Newtech, the same ought not to or might not to, the only relief which is available should not be that it is a remand back, but also the appellate tribunal, by looking at these provisions of the CPC, can decide the matter on its own merits without remanding them. Yes, Satish bhai, can we move to the next slide?
Yeah, Nilesh bhai. I will just summarize the reasons why the matter should not be remanded back. Because the parties had sufficient opportunity to produce all the documents, and they have contested on merits before the AO, and the AO has given decision on merit in accordance with the provisions of law or as per section, whichever section is applicable. And for that reason, the party which is now raising the objection of jurisdiction is not entitled to raise that objection before the appellate authority in appeal, just because the now Supreme Court has decided so. And as per the provisions of CPC, when in such cases wherein the parties have been availed and sufficient opportunity has been given at lower authority, and lower authority has already decided the matter on merit, so such matters should not be sent back, and the right or discretion to remand back the matters should be used in sparingly, or in rarest of rare case, the matters should be remanded back. The different high courts have held, and we have in these judgments, we have highlighted few judgments with these reasons, that lower authority should not run away from its obligation to decide the matters. So now we are coming to the next slide. Nilesh bhai, 1 minute. against there are three judgments which says that as per the provisions under section 2199 of CPC also, wherein the appellant respondent has raised objection on ground of jurisdiction of lower authority, the provision says that if such decisions are not affecting the merits of the case, then the appellate authority should not remand back such matters, and instead of remanding back such matters, appellate authority should decide such matters on merit at appeal stage itself.
Satish bhai, can we move to the next slide?
Yes, yes, please. Next, the composite relief we have already discussed.
Discuss.
Interpretation of manner and hearing before the lower authority. Nilesh bhai.
What is the procedure for inquiry which is different from both set of adjudication? What is the Supreme Court's interpretation on how the authority has to decide a complaint, and the manner in which the regulations are framed to decide a complaint is separate from the AO? Under the scheme of the Rera Act, to determine the complaints having relief of refund and interest with summary of nature of scrutiny of undisputed facts, leaving no discretion to the regulatory authority, strictly interpreting as it is, based on the undisputable document indicating the amount which the allotee or home buyer has invested and the interest thereon prescribed by the authority, whether there is any scope where the authority can wriggle out while deciding, and what is the procedure and interpretation of manner of hearing before the regulatory authority.
Nilesh bhai, Supreme Court, before Supreme Court, various objection was raised. Why AO should not be why AO should hear the matters under section 12, 14, 18, and 19 regarding the whether refund or continuing the project with interest. And Honorable Supreme Court has held that to achieve the object of speedy disposal, specific provisions in Rera are made that the authority will have very limited discretion or very limited authority, and he has to conduct a limited inquiry and should not go on in detail. He has to just restrict his scope of inquiry only to whether the complainant is an allotee or not, and how much money he has paid, and what possession date has been promised. So his inquiry relating to, in the matters of refund or delay under section 18 has to be restricted on these points only. And Honorable Supreme Court has made it clear that to achieve the speedy disposal objective, the authority should not go or enlarge his scope of inquiry and restrict the scope of inquiry to these aspects only and decide the matters. So as per the decision of Supreme Court, the authority now can decide the matter within a 30 minutes. If they follow the judgment and already the existing rules, then the matter can be decided within a minutes only.
Satish bhai, can we move to the next slide?
Uh, 43.5.
What has the Supreme Court held as far as the constitutional validity of pre-deposits in the appeal of section 43.5? Now, what is 43.5? 43.5 is where any appeal comes from the authority filed by a promoter where directing of money is there, which includes refund, interest, penalty in whatever nature. Section 43 defines that if there is the deposit a deterrent for filing baseless appeals, an appeal is filed by a promoter, depositing, there is a deterrent of hearing an appeal or taken on file without a deposit under section 43.5. And that has been interpreted saying that the penalty which is required is at least 30% or such higher amount. But as far as refund, interest or compensation is concerned, the section very clearly interprets 100%. Now, this validity of this section was challenged by promoters in a writ petition, and the Supreme Court has upheld the validity of 43. Satish bhai, can you give some light on this?
Two provisions have been made that if a aggrieved promoter wants to challenge the order passed by authority in the appeal, then he has to satisfy pre-deposit condition that uh, whatever amount has been determined by the authority as per the final order, he has to deposit that amount, 100% amount, with the appellate tribunal, and then only the appellate tribunal will get jurisdiction to entertain such appeals filed by the promoter. And in case promoter is challenging the orders wherein any penalty is imposed, then in such cases the promoter has to deposit at least 30% of the amount with the appellate tribunal, and then only the appellate tribunal will get right to decide or entertain the appeal. So in as far as penalty is concerned, as per the Honorable Supreme Court, discretion is available with the appellate tribunal, say what amount can be deposited. But minimum percentage is 30% has to be deposited. Higher percentage can be decided by the appellate tribunal depending on case to case basis. But as far as the amounts which are already decided by the lower authority in case of refund or in case of delay period, then promoter has to pay 100% amount. So this issue will highly beneficial to the allottees. And the reasons given by the Honorable Supreme Court for such uh, two kind of differentiation is that, number one, to achieve the object of speedy disposal, and to deprive the promoters from filing frivolous appeals on any ground, and thereby to deprive the allottee to get fruits of the orders passed by the lower authority on merits, because the authority has to decide the complaint on section 12 section 18 only on basis of the admitted documents only, wherein the possession rate has been admitted and wherein the amounts are admitted. So question of there is no discretion to the authority available also. So when the facts and scope of authority is limited, the promoter should not be allowed to deprive the allottee from enjoying the fruits of the orders passed by the lower authority. Another reason is given by the Supreme Court is that the allottee and promoter are not equal. Both rights and duties are different, and the promoter has more obligation to be discharged. And in such conditions, promoter has to, if he wants to challenge appeal, then he has to show his bona fide by depositing 100% amount. Because at a later stage, allottee may not require to run from pillar to post just to recover the amount as per the orders already passed by the lower authority in his favor. So to secure the compliance of the orders passed by the lower authority, this provision has been made, and this has been upheld by the Supreme Court. Nilesh bhai.
So can we move to the next slide?
Yeah. Impact of decision.
We've already discussed this.
Yeah.
The impact
So
would be
a question is only a question will arise whether the all pending appeals wherein this what will be the impact of this decision, wherein the appellate authority has for example asked 50% amount. So whether now the allottee can ask appellate tribunal to direct promoter to pay 100% or not. This is the question. Nilesh bhai.
Sorry,
yes.
sorry to interrupt. The entire slide is not visible. One participant is saying.
Sorry.
The entire slide is not visible.
Okay,
तो
okay, okay.
थोड़ा मिनिमम ये कर देंगे.
हाँ हाँ. हाँ. Nilesh bhai.
Yes.
Yes, Satish bhai.
So what will be the impact of this judgment on pending appeals?
The appellate tribunal can suo motu direct all the pending appeals of promoter to deposit 100% in light of this judgment, or an allottee or the party can make an application to the appellate tribunal in view of this latest development, to seeking deposit of 100%, as there is no discretion in deciding percentage to the appeals being filed, and the tribunal has to decide. There is no scope for the tribunal to decide the amount, and therefore the pending appeals, there is two things, that suo moto cognizance can be taken, or the parties can make an application for 100% deposit.
The last issue.
Power of authority to issue recovery certificate for recovery of principal amount. Now, this is a very important aspect, and Rera is and allottees are facing this difficulty of recovering of money once it is ordered. Now, how this judgment has helped interpreting Section 40 for recovery of principal amount, and what are the modes in which, Satish bhai, beyond this, I would request you to throw light, that we can recover the money, because ultimately a allottee is a sufferer. Once the order is passed, it's merely a piece of paper till it is put into execution and there is some recovery which is expected.
So this judgment, limited to this point, this judgment is in line with the Marvel judgment passed by Honorable Justice Katawala sir. So Honorable Supreme Court has admitted and accepted that there is a mistake in the draft or words used in Section 40, and so at para 140, Supreme Court has used the principle of interpretation. It says that it is settled principle of law that if the plain interpretation does not fulfill the mandate and object of the act, then this court has to interpret the law in consonance with the spirit and purpose of the statute. So, by using that interpretation, Honorable Supreme Court has held that even the amounts of refund or interest or compensation directed by the AO can also be recovered by using Section 40 and by issuing these recovery certificate. So that lacuna has been now rectified by the Honorable Supreme Court with this judgment. So lot of allottees who may be who are facing this issue due to in recovery for want of this lacuna is now get cleared, and so thus such allottees will be entitled to recover the amounts as per the provisions of Section 40. Nilesh bhai.
Quickly summarize and go to Q&A question. We will request, before that, we will request Mr. Dilip Agarwal to speak about the association, and also request the members to who are there to join the association.
Yes, thank you.
Dilip bhai, just 1 minute before Satish bhai summarizes this.
Sure.
Webinar. Satish bhai, quickly.
Huh. So after 4 years of Rera, Honorable Supreme Court has settled very important issues that were facing by the aggrieved allottees in getting justice from Rera. And because of these issues which were not settled till date, the allottees were not getting justice as per the spirit of Rera, and they were denied justice, or they were not getting full justice or complete justice from the Rera authorities. And now due to this judgment, they will get full justice. Number one issue, the number most important issue which is settled is that the now single member of Rera authority can handle the complaints filed under Section 31 for reliefs under Section 12, 14, 18 and 19 for interest part, and that AO's jurisdiction is now restricted only to decide the compensation sought under Section 12, 14, 18 and 19. And the manner of filing the complaints has been clearly now described, that both the complaints, both type of reliefs of complaint has to be filed in separate type of forms, and no mixed reliefs will be allowed. So if the complaint are filed with mixed reliefs, then it would be rejected. So all new complaints have to be filed in separate forms. This will help allottees to get easier relief from the Section 18 for a refund or for a delay period. because the authorities in jurisdiction and scope of inquiry has been now restricted only to a inquiry on very admitted documents. So the authority can now decide the complaints within a limited period and can give quicker justice. Now the section 18 has been fully analyzed and decided by the Honorable Supreme Court in this judgment, and it has held that the right under section 18(1) is unconditional, unqualified, and indefeasible. So the promoter has to give interest from the date of possession agreed at the time of selling of flat, number one, or to refund the amount if the that dates is crossed and the promoter is failed to complete the project by that date, then promoter has to give refund with the interest if the allottee does not want to continue with the project. And most important, yes,
Sorry, please continue.
the next important point decided by Honorable Supreme Court is that if the promoter wants to file any appeal, then he has to deposit 100% of the decree amount as per whether it is interest or compensation under section 12, 14, 18, 19, or in case of penalty, then he has to deposit at least 30% of the amount with the appellate tribunal, so that allottees need not require filing separate proceedings for recovery of those amounts. And ultimately, Supreme Court has held that Rera Act is retroactive and retrospective and therefore all the pending or incomplete projects wherein the promoter has not obtained completion certificate and where promoter wants to continue the complete the project, then such projects need or must be registered with the Rera authorities, and Rera authorities then can decide the complaints or entertain complaints regarding that project. Yes, Nilesh bhai.
Dilip bhai, before we start the Q&A question and answer quickly, Dilip bhai, could you just briefly explain how to become a member? What are the advantages of our association to the members herein? And I will request all the members to switch on the camera and mic so that we can have an interaction for question and answer session.
Sure, Nilesh bhai. I can request you to say remove the slide so that the whole screen can be appearing. Yeah, thank you so much. Thank you, Nilesh bhai, for the opportunity you gave to explain about our association. This is one thing which is a privileged platform. Name is Rera Practitioners Welfare Association, registered with the Charity Commissioner. Completely, it is a very you can say a kind of platform which will provide not only this kind of knowledge, as well as it will take up all those issues which are relating to the practitioners or allottees or promoters, to consolidate all those things and represent before the Maharera authority or the state government or any stakeholders wherever it may be required, such that those resolutions or attention of those authorities can be brought to, so that they can amend appropriately time to time. In the recent time, many things has happened, many changes has taken place. This association has been the I can say tool to update those things to the authority, and therefore logical changes has taken place. And now for members, this is an opportunity for you to take the advantage of this larger platform, quality platform, wherein you could see the beginning of the kind of session you have seen today. We have the second session, such session, and the kind of quality materials, the kind of quality judgments, the kind of knowledge. Our speakers, they are the pioneer for formation of the association, are consistently delivering. Their endeavor is to make our professional body stronger, and people may join our association so that they can also contribute, they can get the advantage, and they can get updates time to time. There are three categories of membership available for all of you. One is the ordinary membership. rate is 1,000 rupees, but this year is very limited time. You can take the advantage by paying 50%, means 500. And then associate membership rate is 500, but the discounted rate, our committee has taken decision to take only 250 rupees for this financial year, and for the whole life. Thereafter, no need to pay anything. You will be life member for by paying 10,000 rupees. This amount will be accompanied with the GST 18%, of course, which is applicable. And now, interest fees is 100 rupees. That is to be added. Those who will be interested, this circular, my name is as a coordinator, as well as person accountable for enhancing the membership, taking that responsibility to contribute to this association. I am accountable. Any of the committee member will support you. You can demand from any of us. We will support you.
Can you share the link of the forms? Sorry, Dilip, in the
Okay.
chat box.
Yes, in the chat box. In the meantime, Aditya, please do that. Otherwise, I will do after my this 2-3 minutes. And secondly, you can see we have started taking the kind of outsiders, quality people like ex tribunal member, appellate tribunal member. Such people are very rarely available on the public platforms. But they being with us in spending 1 hour by sharing their own experience, and when we appear before them, we are afraid and we share whatever we share, but we don't know what they think about us. And today you could get a sense how they relate us and what they think from their perspective, as well as what they expect from us to present them. And that advantage we can take when we are appearing before them. And now lots of we had planned to have only Newtech promoters judgment today, and inside of that judgment, lots of other judgments, our deserving, well-deserving duo advocates, Satish Dedhia ji as well as Nilesh Gala ji, they have drafted and presented in a way that they were having the delegates. They are having the kind of panel. They presented one by one, and they put the question other answered in a way that we got 100%. And this crowd, I think, will bring at least five people from their life to enrich their knowledge, your friends' knowledge, your colleagues' knowledge, so that our association will be stronger. The moment we get number of membership in this kind of association, which is very newly born, if our Rera has born 4 years, 5 years back, and now Supreme Court is also taking fast decisions when matters comes about Rera. In a 4 years time, when you can get a decision on various aspects by Supreme Court, where we have the experience that 20 years or 30 years it takes to be decided by Supreme Court, but in the Rera matter, so fast, such critical matters have been decided and brought the clarity. One thing I am clear is, such clarity will reduce the number of litigations. When we are going to the Maharera authority or somewhere, whatever they decide, their choice. Now, since this precedent is there, now decisions will be faster as well as based on the solid precedents. And therefore, and we are also clear what kind of now things we should file, where to file. AO is really authorized, and certain things which we have to file with them only in the Form B. Other things will be taken care by the authority. These are now very clear. All five aspects which were very critical are now get settled. And obviously, law is there, then there will be some unsettled issues. And there is a development or redevelopment related. Suman sir shared some experience about him, whatever he is thinking from a judiciary point of view, and that point of view might be coming from the High Court, Supreme Court, then that will be having a precedent for others. And we are hopeful that in this area there are a lot of things to be done. Apart of that, there are more than 3,700 stalled projects left declared, and there is no clue where we are going, what will happen to those left projects. And obviously, this platform is working on that. Believe me, you people may contribute, and we as a team, we as a group, we as a association will be impacting, and our Mumbai, this association will be impacting the whole of the country. Once things will be brought to the authority or the state government or the central government, and then obviously things will be so clear that in future such kind of number of stall or lapse project will not happen again. And these are the beginning. In the very last 70 years of this, jugglery is now cleaned up, and people are now very clear that a promoter should be straight and transparent, and otherwise their projects might get stuck anywhere, not only because of their own problems, but because of the first of all, Aditya ji, can I propose hearty vote of thanks for the speakers, or they will have the question answer session?
Yes, sir. Let us first have question answers, then we can have a vote of thanks.
Okay,
If the
okay. Now
speaker,
I am handing over to you. Please take on.
yeah, okay. Satish sir, please.
आदित्य जी एक मिनट आदित्य जी
हाँ,
आप एक खाली बोलिए कि anyone who wants to ask any question should not reveal the names of the projects so that the any controversy can be avoided.
yes, yes. So please, all the participants, kindly do not mention any project name or promoter's name in the chats or in the session also, because this session has been recorded also. So let us keep it to the plain queries which we have, and all your queries will be answered by our speakers. Can we start with the question and answer, sir?
Yes, Nilesh bhai will answer.
Okay, okay. So, you are on mute.
Aditya ji, you will have to unmute everyone so that they can.
Yeah, first of all, we can let us finish the questions in the chat box. Some have already
Yes,
posted.
yes, yes.
Okay. Before that, Manoj ji, he has raised the hand. Manoj Nail, please mute yourself, unmute.
Sir, आपको
Yeah, can you
unmute.
hear me? Can
Yes,
you hear me?
yes.
This is Manoj.
Yes.
Yeah. So the question to the panel: if a particular promoter has delayed a project, pre-COVID, I mean the date of a sale agreement had a date of delivery much before COVID hit, right? And the project got delayed beyond COVID and still not completed. Then does promoter have the benefit of using the force majeure clause on for COVID and take benefit of that and use that to calculate the overall compensation?
Manoj ji, your question has been already answered in our webinar, where it clearly said that the COVID period, although there has been grant of extension for completion, does not take away your right under the agreement. The Newtech judgment is very clear that it does not take away your right as far as Section 18 reliefs are concerned.
Okay.
Suraj ji has raised
Yes.
his.
Suraj Swami, can you unmute?
I'm just trying.
Yes.
Yeah, I have a question for the panel. Just enlighten us with regard to the rights of the allottee with regard to access. Because many times we have seen in the project where it's a composite project like slum and the pre-sale component. So there is a particular type of access is being granted while selling the flats. Over a period of time, that particular access gets changed. So what is the rights of an allottee in this case?
So could you just, Suraj Swamiji, access to what? The clarification required to a slum.
Access, like see, when we buy a flat, we have been represented that this would be a separate access to you. There would not be common
Oh,
access.
right of way, right of way, right of way.
Right.
So in this approved plan or the tentative plans or in the brochure, if the same is shown as a tentative or a proposed layout road towards the access of a project through a slum or through any other this thing, then your right available is twofold. Either you can seek relief or refund, or you want to stay in the project, then seek compensation for the damages or the hurdles which you are facing to reach a particular destination because of that road not being provided for. And of course, the society or a proposed society can take up the issue of directing the promoter to make sure that the road is completed.
So the road, generally developers are ready to construct a road or a right of a way. Only thing is that whenever you must have also seen that slum projects and the free sale, generally they provide a separate access or a separate right of way to the, to the slum plot and to the free sale plot. So many times the while selling it, the builder represent, but while actually in practice, when you construct a project, you give the same access or the same right of way to both of them. So
This query is a very technical and a project-based centric. So this you will have to see from the project and the plans which are sanctioned or the layout which is sanctioned. Only then and we would be able to comment on the same. Satish bhai, if you have any other view on this to help Mr. Swami.
Yes, sir. Mr. Swami,
yeah,
you need to compare the plan which was shown to you in the brochure or any other material at the time of sale of the flat, and compare it with the plan approved by the builder. And if there is a difference, as rightly said by our advocate Gala, that in case of difference, then you will have get two rights: either to continue with the project with compensation for the losses caused to you for the false statement given by the promoter at the time of sale of the flat, showing that there will be two different access, and now there is only single access or common access. So this is a loss for you. So you can show the both the plans, show the difference, and seek the compensation if you want to retain in the project. And otherwise, you will get a right to take a refund and withdraw from the project with interest, as rightly said by Nilesh.
Can we take up any other questions which are there? Can you unmute everyone, Aditya ji?
नीलेश भाई पहले चैट बॉक्स का ले लीजिए ना.
जी जी जी. So can we?
Can I read it?
Yes, yes.
Yeah. So Victor D'Souza, he is a participant, and he has asked a question that in case of a subvention, suppose 80-20 scheme is there, and 20 you have to pay at the time of booking, and at the time after possession, through tri-party agreement, rest of the you have to pay, which is the end date is the possession date, and by charging a premium, you have to pay the rest of the amount. But if in this case the project is delayed, then the tri-party agreement is valid or it get expired, and what are the right of the customer and responsibility of the builder in this case? So what will happen to the tri-party agreement, and what are the rights of the customer and responsibility of the builder?
Satish bhai, would you want to answer or can I take it?
नहीं आप बोलो आप.
हाँ, विवेक जी किसका क्वेश्चन है ये?
Victor D'Souza.
हाँ, Mr. D'Souza, very interesting question, and a lot of allottees are facing this 80-20 scheme, subvention scheme. Tri-party agreement is executed between the promoter, allottee, and the bank. In case of a default from the promoter, in these situations, you can seek relief from Rera seeking performance, that the promoter be directed to pay interest till handover of possession, or you have a right to exit and seek refund if he defaults on the tripartite agreement. In the tripartite agreement, if you see, there are standard clauses where you also have agreed to that in case of promoter defaults, an allottee will pay. So you might seek reliefs under that agreement along with your agreement for sale. Make a choice between either continuing in the project or seeking exit if there is any violation. Mr. D'Souza, hope this solves your query.
Yes, yes. Sure. Thanks for answering.
Next question is from Vivek Maskarji. He has asked a question relating to a particular allotment letter of any certain project where it is dated back to 2014 and it contains all the ingredients of agreement, but the possession date has not been mentioned in that case. So whether the settled law, that is 3-year period from the date of final payment, can be taken as a legal and valid, and any citation or any judgment specific to this particular situation?
I think the Supreme Court has held in the matter of Fortune Infra, where the court has said that if there is no date of possession and in case of a standalone building, 3 years is a good and a reasonable time to complete a project. And therefore, that is a benchmark, and appellate tribunal also, Rera appellate tribunal here also has considered this judgment and given findings and followed that judgment in many of the orders. Vivekji, you can find those ones.
Okay. I hope, Vivekji, you're satisfied with the answer. Yes. There are no more questions in the chat, but if any participant would like take any questions. Yes, sir. Dilip, sir.
Yes, I have one question. I say, in case of redevelopment of society, right? There are members in the beginning, they decide about to take some additional area. Say they are allotted 600, they want 200 additional more area and going to the bigger flat. And whether they will be entitled for the Rera benefits before the registration of the project.
Sir, as already discussed with our chief speaker today, Kuleji had said that even if he is not a purchaser, the Kuleji has interpreted and given a dissenting judgment saying that he is an allottee but as far as the purchase of additional area is concerned, that has been now a settled law, and in the tribunal and authority has decided in favor of allottee, because they step into the shoes of allottee as far as today's interpretation is concerned.
Yeah, only thing, if there are no outsider purchaser in the same project, only resident members, they have purchased. In that case also, that same ratio will be applicable?
Yes. If it is registered with Rera, yes.
Okay, perfect. Second question, one more question is, suppose society is getting redeveloped and the developer is taking over with development agreement. Now, Rera authority wants landowner promoter also to be disclosed and all those things, right? Here question is, society do not have any area share, neither they do get revenue share. Okay, only members will get whatever they will get as per their decided terms, right? Whether this will be applicable still to...
This issue is now pending in the High Court in various matters. This has not yet been come to a conclusion like Newtech. This is a grey area where there were circular issued for directing landowner to be as a co-promoter, where some of the society had challenged it in a read petition. The Rera has withdrawn that circular. Again, the new circular has come into force where again landowner is defined as a co-promoter. But there is a contractual obligation between them where it has to be seen whether it is on principle to principle basis. Because if society has no role to play in the redevelopment, then there is a difficulty of fastening any liability under co-promoter. So that interpretation, there are 3-4 judgments by the appellate tribunal in Untitled matter and Goregaon.
Yes, obviously, but Maharera is not accepting so far.
So, that interpretation has not come forward yet in Maharera. They still continue to be giving different view.
Yes,
Sunil would be aware. Sunil should, Sunil Keval Ramani. Sunil also practices in Rera.
Okay.
Sunil must have come across something like this. Sunil?
So I think it is still sub judice. I mean, there needs to be clarity about this.
Have you come across any of that? Satish bhai also must have come across this.
Yes.
Sunil, any of your matter where this issue of Agarwal ji, which is yet decided?
No, none of my matters, but I think I read a recent matter in which the society was liable to the third parties interest created by the developer.
This is the order of chairman of Rera, not the appellate.
Correct.
Yes.
So higher courts have not yet decided those issues. Satish bhai, is there any order deciding that issue?
Marera has decided in favor of the allottees and
Allottees,
against
correct.
the society, but appellate tribunal and high court have are yet not in
Different view.
favor.
They have their different view. They have don't have comparative.
So in such circumstances, we have the alternative that to keep pending such matters till the law is settled and save ourselves. Till then, they keep the matter pending in some or other way.
Any other questions from any of the members who are there?
Yes, Victor D'Souza, I think so. He raised a hand.
Yeah, one more question. Before 2030 plan, the builder had sold that building is for, suppose example, it's for 15 floors. But after he delayed the project and after 20 plan was implemented, he increased the project to say 22 or 23 floors.
Victor ji, you can check your
He
video because
raises
your internet is weak. Your voice is not coming.
Okay, I'll close the video 1 minute.
Yeah, now you can speak.
Okay. My question is, suppose before the 2030 plant implementation, I booked a flat in 2014.
So, I have understood your query. You have said that he has not implemented the plan. Now the FSI has increased. He's changed the plans from 15 floors to 22 floors. What are your rights?
Yes. Yes.
The answer is very simple. Section 14 says that if there are if he has sold to 2/3 of, if he has sold some sale units, he has to take consent from 2/3 of those members. If you are the only member who he has sold, it is mandatory for him to take consent from you. Till then, he cannot construct. You can file a complaint in Rera to seek injunction on construction on the above flats.
But he prudently he didn't he signed the agreement prudently after some time for 22 floors. Okay, so in that case, that is the consent, or should I?
Well, with that you will have to seek some expert advice by going through those papers, and that only we will be able to advise on that. So this forum or the platform will not be that sense available for, because your agreements will have to be seen. Yes,
So because the
Indrani.
two agreements are
Yes, Mr. Jason.
Hello.
And hello.
Can I ask?
Yes, Mr. Indrani.
In January 2018, we have got the order from Maharera to give the possession in December 2018. Otherwise, he has to pay the compensation from January 2009. Okay. Now, in 2022, builder has applied for OC. But still, builder has not paid the compensation money, or he has not adjusted or credit the payment of our compensation money. So what, Nilesh, can you give the answer for this?
Sir, I believe that there is an order from Rera in your matter in giving compensation. There is no appeal filed.
No, we have given only for the execution appellate to execute the order.
Now that, is there a warrant issued in your matter?
Not, I don't know exactly, but
you will have to follow up with the Rera authority for issuing of warrant of attachment, and the same has to be executed.
No, what happened in 2019, we have applied for execute the order. Okay. but still because of COVID, that execution is in the delay controlation. Okay, but after that hearing is started, still the hearing is pending in appellate.
Nilesh bhai, what he is saying that Rera has passed order and execution is denied. So they have challenged the order denying the execution and their appeal is pending.
So that denying of execution, either you could have challenged by way of a writ or by way of an appeal. Now, since you have filed an appeal and the procedure takes its own sweet time, let the appellate tribunal first decide on the execution and then there will be a warrant issued. That process is there. Once the warrant is issued under MLRC, you can seek reliefs by way of a writ petition. Seeking
But Nilesh, at this moment,
sir, at
builder
this
has
moment
to pay
you can't do
almost.
anything, sir. You are in a catch-22 situation where you can't do anything.
So we have to follow this appellate.
You have to pay the money without prejudice and take possession. Otherwise, you will not enjoy the flat also. Not in the greed of not paying that 10%, and that execution also will take its own sweet time.
Okay. Okay, thank you.
Okay. So we have one last question, sir, in the chat. That a lot of writ petition and second appeal are filed in the Bombay High Court regarding unregistered projects with Rera and to decide on refund. So any recent judgment to have a jurisdiction in this case? Otherwise, all such matters will be thrown out of Rera by saying no, out of jurisdiction. So any such recent judgment?
There are two judgments. One is the judgment of Zain Khan in petition 902, which I had only argued. And apart from that, again, Zain Khan in second appeal, and there is one more Mangal Murthy, which is in second appeal. These are the two matters where question of law have been framed by the Honorable High Court. Because of the COVID situation, final hearing could not take place. But we are expecting some conclusion on those issues.
Okay. Okay, fine. I think so. All the questions we have properly answered all the questions. Just a few things, and afterwards I will hand over it to Dilip sir for vote of thanks to the speakers. Yeah, basically we today was a fantastic session, and we had more than 50 participants in this session, and we urge you all to be the member of this association because a lot of activities are going to undertake under this association, and it is for the benefit of all the stakeholders, all the professionals and other stakeholders also. So we are planning for various representations, various appeals and PILs. So we require a good membership base to represent to the authority, and we need a strong membership base to be heard in front of the authority. We request everyone to be the members. We have lot of life members coming up in 2-3 months. We have many life members who have taken active part in the association. So we expect you all to become the members and be a part. And there are a lot of opportunities as a speaker. If you want to represent any issues, you can get you can represent before us, and we can take those issues to the authorities at Mahariat level also. So please be the members of the association and take active part in the all the activities of the association. That's all. I will hand over to Dilip sir. He's also a life member. He is an active member of our association, taking all the leads in the association. So Dilip sir, up to you. Please give a vote of thanks to our learned speakers.
Yeah, thank you, Aditya ji. Thank you so much. And first of all, respected members, you are more valuable because we all are only amongst you. Therefore, we are all respectful. First of all, I acknowledge our president, Ashwin Shah, a chartered accountant, and he took all the initiative and provided the leadership to have such association in place. And the person taking the lead is always a leader. And all such leaders, we are with Ashwin Bhai. And at the same time, I can see the forum which is formed is consisted of people who are highly accomplished people, highly enlightened people. They all are speakers. You will not find such kind of association where all people are leaders. They are experts. They are in their own subjects. You see, Ashwin Vaisa is one of the convener of the Western India Regional Council Chartered Accountants last year, and he has been providing his rich experience at different platforms. And Satish Dedhia ji, Vice President, and today you could hear him, the kind of quality knowledge he's having. And Nilesh Gala ji, kind of sharing itself speaks a lot. Okay, what kind of knowledge he may be having, where how he will be impacting the judiciary by his rich knowledge and interpretation of the provisions and acts and laws. And Aditya ji, the treasurer, and you will surprise in this month itself, I can hear him third time coming Sunday. So means I am also one of the speaker. People amongst you, I can see lots of people who are having extraordinary knowledge, and your knowledge will value it. यदि हमारा 22 माला है तो हम उसको 100 माले तक लेके जाएंगे नॉलेज के लेवल में, and that will and charges for the membership is very negligible. If you see the kind of one day, if you could have seen in 2 and 3 hours time, you could earn at least 10 lakhs of rupees out. Only one day session could have given you that much material, and such kind of various other things in every month, maybe once or twice we will be having this quality seminars, a part of articles, a part of various other materials, day-to-day updates, and members who will be joining us will be added in the WhatsApp group. They will be getting updates. Sometime you may be having some queries, and you will get the second opinion from the group. And what will happen to our knowledge? How we will be forwarded in our practice? Therefore, this membership fees is very negligible. Coming time might be, जैसे बोलते हैं ना कोरेगांव क्लब में हम 50,000 में मेंबर बने और आज 18,72,000 रुपया चार्ज है उसका मेंबरशिप. तो हमारे एसोसिएशन में लोग बोलेंगे हमें मेंबर बनाओ, हम लोग बोलेंगे बाबा बहुत हो गया, या फिर इसका पता नहीं कितने भी चार्ज हो सकते हैं. तो कॉस्ट आता है. We have to go at different platforms with different expenditure. As of now, we don't have any corpus, and intention is not to create the corpus, but to have membership base. This is the basic intention, and I hope you all will be contributing by way of 5-10 people from your life, and in by the end of this financial year, our strength must be 1,000 members. This is what I expect minimum. And with this, I propose a very hearty vote of thanks to the duo. क्या बोल सकते हैं, ओपनिंग बैट्समैन हमारे इधर सेशन की तरफ से हम बोले तो, and they both took such a fantabulous leading. They could lead very powerfully, left no stone unturned. They delivered everything. They did not bother their personal life. Hour-wise up to 1, they could spend even beyond 2 o'clock, and still they are hungry to deliver. These people are with us, and we are proud to have them. And Nilesh bhai, Satish bhai, I hope that he is not well also. He is somewhere infected, or he is dealing with his health or family issues, and still he is with us. The kind of commitment is very important, and intention is also very, very important. लाइफ में बहुत पैसा है या नहीं है बहुत महत्व शायद नहीं रखता है, बट हाउ यू आर एसोसिएटेड एंड व्हाट काइंड ऑफ पीपल यू आर एसोसिएटिंग is more critical, and that is what I am taking on personally from this today's platform. And having without any study circle or anything, and 55 members attending this kind of program is a extraordinary thing. And Suman साहब has added, बोलते हैं ना चार चांद लगा के चले गए, और उनका जो शेयरिंग था from both the sides and was extraordinary, and that could have given a lots of opening for us to play batting. बोलते हैं ना बॉलर तो कैसा भी बॉल फेंकेगा, बट हमें तैयार रहना फेस करने के लिए. तो now we are now very much equipped with this, and I request all the members for and on behalf of Rera Practitioners Welfare Association, I propose a very hearty vote of thanks to both our well-deserving speakers. Yes, please give a round of applause.
सर ये सूरज स्वामी जी ने हैंड रेज किया है.
I just want I just want that link to be shared where the payment of.
I have shared the
membership
link in the chat box.
Okay.
You
I
can
just
click
missed that. I think I just missed that.
Aditya, what I request, let us conclude the meeting and you leave this session alive for some time. You may also go off video, and those who will be interested, they can click the members form and they can register. 5 or 10 minutes you can leave this, right?
Yeah,
It's
yeah.
2:18 and you can close the...
Sir, Swamiji, you can go to our any social media handle and take the link also. We are going to upload it on that also. Aditya ji, we will do that on LinkedIn, Facebook, and Twitter also, so that everyone who wants to take those forms can do it from our social media handles also.
Right,
As
right.
of now, sir, it is handy right now. And Aditya ji, you can switch off the recording. That is unnecessarily taking space. Yeah.